Yes.
My lord, may I have my lord's kind leave to mention this matter? My lord, the election matters that came up before my lord on 24th. My lord, in para number 19, the name of the intervener is not mentioned, my lord. It's written and others. I understand that there has been a lot of interveners in this matter and it's written as others. My lord, the Union of India, neither the government leader is taking service in this regard, my lord. My lord, kindly includes the name of the intervener in the order sheet.
Let us check up. You give a letter. Let's see.
My lord,
Whose name has to be included?
Very well, my lord.
my lord,
Grateful, my lord.
Inclusion, upgradation, Monday you make a mention. Already we are.
my lord,
I
very urgent.
went to the academy, so the
My lord, one indulgence for I have already understood your lordship's desire. My lord, this is with regard to that matter, my lord. Your lordship may recall that during pendency of the matter, my lord, the respondent ECL took adjournment, and when the matter is session, my lord, they were proposed to, my lord, invoke
we granted an interim order.
my lord, so far as my difficulty is, my lord, in the impure letter, they have also said, my lord, that they would be proposing to, my lord, recover a 65 crores damage within one.
List the matter. Is
Well,
it
this is
running?
matter in the list which is down in this as an adjourned
What to
motion.
do, sir?
Well, the urgency is, my lord, I am also debarred for 3 years without giving, my lord,
Which is your serial number?
106. It's a new matter, but to the extent that your lordship has not heard the matter
All
on
right,
merits.
we'll upgrade it. We'll upgrade.
106, my lord, only, my lord, one indulgence,
Don't you note down.
my lord, made appear as a specially fixed, my lord, with the deepest of respect.
Other mentioning on Monday.
I pray your lordship's leave to file without certified
Without certificate copy.
Lordship, I'm praying for leave to file an appeal without the certified
Yes,
copy.
yes. Leave
Deeply
grant.
Without certified. Yes, mentioning notice,
What is your matter?
The mother is badly tortured by the son.
mentioning notice. 106.
Though the police was told
Is it running in the list?
running. Number is 89.
89. You give.
My lord, this is an appeal from an order passed in the contempt jurisdiction by the Honorable Single Judge, my lord. My lord, the difficulty is that the contempt is running in the list before the Honorable Single Judge, my lord, and we have challenged the last available order, my lord.
What is the direction given?
My lord, the direction is, my lord, from the main order, my lord, there was a direction to issue the admit cards for the examination purpose, my lord. And thereafter, the admit cards was issued, my lord, but the subsequently examinations could not be conducted for the petitioners, therefore, my lord. And now the persons are before the contempt court seeking for
Why you couldn't permit them to attend the exam?
my lord, the difficulty was that the order was not specific enough that what exactly we
You
were.
can't interpret the order. If you had to interpret the order, you should have gone before the single bench.
My lord,
Or you agree for a supplementary examination, subject to the outcome, results have been directed to be withheld.
no, my lord. The results.
You could have made a prayer. See, what is the course?
My lord,
Course, what is the course?
my lord, this is not the course, my lord. It is a government recruitment process, my lord, of the ICDS. There is the Child and Women Welfare, my lord. My lord will kindly hear the matter, my lord, before the.
But is there an order of some punishment has been? Is
No, my lord, not a punishment.
Then how an appeal is maintainable?
My lord, there is a subsequent direction to give an implementation, my lord. We want to get it tested before the Honorable Division
For
Bench.
class 15, you want to maintain an appeal.
My lord, this is a section.
Who appears? You are appearing for the respondent.
My lord, this is not in the list, my lord. We are just praying for a primary.
What is your matter?
Only one. My lord, I was my lord telling me to come back on Monday. My lord, this matter will not appear on Monday. It's a appeal matter. My lord, petition is 89 years old.
It is running in the list.
It's 78, my lord.
78.
Well, kindly upgrade, my lord. Appeal matter. Add 70.
Oh.
No, it's not appeal matter. I stand corrected, my lord. Residuary matter. My lord.
Residuary. Okay.
My lord, 78.
Item 78. Please note down.
Daily list, serial number 1.
I am for the petition. I am for the respondent. Led by Mr. Soman Majumdar.
And why is it coming under the caption to be mentioned?
I don't know. It has been mentioned, my lord. I have given notice yesterday that it has been mentioned, and your lordship was.
I think somebody said some urgency. What is the urgency?
May I just remind your lordship, this is an appeal filed by me, my lord, in 2021 against an order passed by the learned single judge, my lord, whereby my selections, in fact, I was working at that time, was cancelled, but without making me a party respondent, my lord, pursuant to a tender. That appeal, there was a interim order passed by by the Honorable Division Bench.
Now, who seeks for vacating the interim order?
My lord,
My
the writ petitioner responded.
And you are for the appellant.
I am for the appellant. I have no objections. Your lordship kindly takes up
Department
any
had
day.
found him to be an ineligible bidder.
My lord, I'll show that how this has been done. My lord, it's an engineered, my lord, read I would, my lord, show from the record. My lord, I had deposited the security and money. My lord, in fact, I didn't receive the bill and I was not made party. Learned single judge observed that there is no requirement of making me party. When the deed was filed, my lord, after I have been selected, I have been, my lord, started working.
On what day? See, where is the interim order? Date of the order?
My lord, it is the interim
of
order
January
is
21.
25th of January 2021. In
26?
fact, I have been robbed of my benefit of working there, my lord, because the certain ad hoc arrangement was allowed to continue. When I tried to, my lord, get this matter had, I could not, my lord, despite my best effort. Now,
The Honorable Single Judge found that the government was somehow going back or not following its own circulars.
this is a yes, I tender. Those circulars was not applicable. This is not a second call tender. This is a stress call because the schedule was changed, but everything has been, my lord, suppressed.
And how long you're likely to take, both of you?
My lord, I will not take much time, my lord.
Much time?
20 minutes, 15, 20 minutes.
How about Mr. Mazloom?
But I just read two paragraphs from the Honorable Single Judge's order. Sorry,
What happened?
I was thinking, Lord.
Why is this excitement? Sit down, sir.
I'm just, my lord, I'm begging pardon, my lord, I'm apologizing.
No, you have mentioned the matter.
Yes,
Yes, so we are hearing the people.
Yes.
Council is here. What is which paragraph you want to read?
Paragraphs 27, 28 and 29. At page 11.
Memo-টা দাও।
But you are the single successful bidder. But the terms and conditions of tender provides for confirmation.
Many participated. Some were found to be ineligible by reason of their candidature and some had not submitted documents. So in the process, I emerged as the successful bidder, not the single bidder. There are other bidders.
Other bidders.
He was never emerged as a successful bidder. I was selected as successful bidder. Just I'll show
And
certain pages.
You are appearing for which respondent in the appeal?
I was not made party. With the leave of the appeal, I filed, this appeal has been preferred. I was, the work order was granted in my favor on 9th of December. This writ petition was filed on 14th of December 2020, and the writ petitioner did not make me party. Kindly take the order.
And what was the contract?
Contract for supply of cooked diet to the ESI hospital.
All right.
That
What
was
is
the
the
contract.
period of contract?
That in the tender notice, that period
Should be for 3 years.
Probably 3 years, my lord, I'm just showing.
Supply of cooked diet to indoor patients of ESI hospital,
Yes.
Durgapur. For 2 years, it is already over.
It is already over, but I didn't, my lord, I was not permitted to work.
So what to do? Can we set the clock back? Now they would have invited fresh tenders. The entire exercise will become academic.
Yes, but let them, my lord, they have not yet invited any.
Who appears for the ESI? Who appears for the ESI?
It should be the state, not the ESI.
All right, state.
My lord, initially,
We don't know whether a state has been,
my lord, one Manali Ali appeared, my lord.
no, whether state has been given notice of mentioning. The 2 years is already over.
There is probably a renewal, my lord,
But
I
it has
just.
been, there is a renewal and not this process continues.
Who's,
But he ultimately he is benefited.
no, he says he
His
is,
alter ego, his alter ego. His alter ego is benefited. It continues for time to time. It does not take, the retendering does not take place. It
no,
continues.
we'll ask who appears for the state. We have to hear the state and then fix a date for the appeal. In fact, now the challenge itself has become academic, assuming you succeed. And the appeal is it's dismissed. Still, can we put the clock back, set the clock back and say the tender has to be given prospectively for 2 years to you? Probably we can ask them
To consider me for the next phase.
Please give notice to the, if something can happen. On behalf of? Can you inform them?
Probably Mr. Samrat Sen is.
Samrat Sen was appearing before the land
No,
single.
we will keep it next week under the same caption.
Yes.
So you, Mr. Siddiq, you please inform him and to find out what happened. Because the 2-year period is already over, but the tender document provides for extension for periods of 6 months. That's what it says.
Probably that is also over by now.
1 second. Where did I see that? For 2 years with effect from the date of signing of agreement or contract, there will be an extension of for 1 year on expiry of the schedule at an interval of 6 months each, provided the agency agrees to comply the extension order, maintaining the same quality so and so and same terms and conditions.
There is total 3 years, my lord, provision.
So that is subject to condition. Suppose he
Subject
says
to conditions. my
price
lord, if
rise,
Yes, yes.
I will not agree.
But there was a, my lord, 3 years. my
And
lord,
as of now, you are not supplying.
No, because on the basis of the order of the learned single judge, my lord, and the division bench has, my lord, permitted the ESI to make an ad hoc arrangement. My lord, I was, my lord,
No, we will direct the ESI, I mean, the state government to call for fresh tenders. How long you can go on ad hoc arrangement? Then it will be 1 month agreement, 3
but
months.
my lord, this
3 months.
my lord, if you
All right.
permit me to make submissions, my lord, the order of
To
the
give
learned single
first the
judge
learned
to go.
counsels for the parties. It appears Mr. So-and-so appears for the respondent state, who's the contesting respondent in the matter. Since it pertains to a tender called for by the government of West Bengal. Let the matter appear on so-and-so date, and the said date, the learned advocate appearing for the state of West Bengal shall be present in court. Give one date. 3rd August. 3rd August.
Under the same heading, if it's so please.
Same heading, under the same caption.
Serial number 2.
But has to be mentioned, my lord.
Yes.
I'm not happy for the pollution control board.
She has filed CAN 1 of 2023 and 2 of 2023 to restore the matter which was dismissed. That can be allowed.
No.
There's no problem.
No problem.
What is your writ petition?
Lordship, my
Restoration allowed, is it? Oh, yes, sorry, sir.
Subject to correction, it was
Oh,
allowed on Friday.
restoration is
It was allowed on 21st of July.
21st. What is your writ petition?
Lordship, my petition based on noise pollution.
So you show the prayer.
The prayer, my lord, page down to Pachina.
Where is your writ petition?
Page 12 of the writ petition, subject to correction.
Lordship,
Page 12.
Mandamus commanding the respondents 1 and 2. Who are the respondents 1 and 2?
Well, the state respondents.
State respondent.
State
Police, specifically
The
the
police, specifically the Park Street Police Station.
First is through Commissioner of Police, Lal Bazar, Police Headquarters. Second is Deputy Commissioner, South Division. Third is Park Street Police Station. Fourth is Pollution Control Board. Mandamus to intolerable nuisance of beating of drums. Prohibition thus issued directing the local PS to restrict beating of drums in residential area. Praying to take legal action for breach of peace of common public. Strict action against the lawbreakers to stop this fatal nuisance. Direction of the police not to humiliate and harass the complaint. Why they are
Lordship.
harassing you?
Lordship, whenever any complainant is giving complaint, Park Street PS are harassing, even they are insulting, humiliating publicly. They are saying, put cotton in your ears, and they can't do it.
It is
It's
wrong.
a,
Sir, actually, decision of the Supreme Court, that full gospel. Have you got that decision?
Which one?
Full gospel,
Full gospel.
Church of India,
Oh, yes, yes.
where they were. Yeah, have you got decision?
Lordship, I have got the single bench order for noise pollution
Get it, get it.
Okay, let's put the part.
Oh, oh. Ito ki dichi.
and drug peddling, both.
Just put drug peddling also.
No, no,
Drug peddling.
you have enclosed something here.
Drug peddling to written in.
NGT has also passed an order, I think.
On several orders, my lord, all based on the noise pollution rules of 2000.
Yes. So will you not? Yes, you have enclosed that judgment.
Yes, Lordship, in supplementary affidavit.
In supplementary affidavit. Have
We
you
have
got?
not received the copy.
Yes,
You give one
yes,
copy?
Yes, I.
Supplementary affidavit, I also have not received. And we have an extra copy?
Yes, this.
Oh, thank you.
And you have already moved the single bench.
Lordship, but still I'm struggling to stop all these.
How you can, you move the single bench, you come here and for the same relief?
But the day before yesterday, I called Lal Bazar control room to stop this, drumming. The cop told me, bring the order first. I said, the matter is pending in High Court. It's a pill matter. He said, bring the order first, then talk. There is no specific order for drumming. According to them, there is no specific order for drumming. Drum is not a noise polluting instrument, Lordship, according to them.
No. Can you search this judgment in the net?
কি বই আনাচ্ছে noise pollution rules এর আমার কাছে আছে।
পাচ্ছি না। খুব জোর লেগেছে।
মনে করলেন তো স্কুল লেভেল রেজাল্ট বেরিয়ে পরীক্ষায় ফেল করে গেছি হাতে নিয়ে বাবার কাছে যাচ্ছি এরকম দিনও করছি।
In court judgment, Church of God, just search the net. Get the citation.
জাজমেন্ট
আমি বলে দিচ্ছি আমাকে বলুন না এইটা দেখিয়ে বলে দেবো বলে don't consider this.
কোথায়
এই
judgment
যে-
আছে?
এই যে- এখানে কিন্তু একটা matter আছে।
But if this, she says day and night they are beating
My
them.
lord, my instructions from the concerned police station is that during the month of Muharram, this beating of drums takes place
No,
for the
throughout the day.
not for the day and night. They have held a coordination meeting on 23rd of July of this month, my lord, and they have said that the drums will be beaten at during the hours which are permissible. That is from 6 a.m. to 10 p.m. Not beyond that hours, which is
Continuously.
no, not continuously. They cannot. One person cannot sit there day and night and
No,
beat
she
drums.
says there are
Yes,
a lot of
Lordship.
boys are doing it.
It's not like that. It's
Lordship.
not like that. And the police has always paid heed to whenever she has come to the police station. They have always paid heed to a complaint. They have visited the spot. And my lord,
No, suppose 5 times prayer is there.
my lord,
Huh?
Huh.
Or during this festival season, suppose 7 times there is prayer. During that time, if we, will they be beating the
no, they
drums?
cannot.
Ah.
No, they cannot. And that is not to be, my lord. I know it for this is my personal experience. Whenever they are going, they are passing. The procession is passing by beating drums.
Hmm.
My lord, whenever they
stop.
come near the mosque, they stop even if the prayers is not
Get
being
the
performed.
citation. They stop.
They stop. And when there is azan, they stop. When the prayers are going on, they stop. I know it for my lord. I know it personally. This is my personal experience. I should not have, my lord. But
No,
this,
no.
this
That's
they
why
stop.
we are asking.
This one sect of the community, my lord. There are different sects. One sect, this is the morning time for one sect, that is the Shia sect. And for some Sunni sect, my lord, it is believed that this beating of drums is to win the war between the good and the evil, because the grandson of the Holy Prophet was martyred on the 10th day of this month.
Hmm.
So, my lord, this is beating of the drums is only a significant thing. It is like beating.
No, you regulate that.
That is to be regulated, and we are doing that.
It should not start before 8 a.m. See, there will be school going children.
Right.
Examinations will be
I
there.
bought on to your lordship. That has to be.
There will
That
be
is what I have
people
also.
who are sick, terminally ill people.
That is what I have also told, my lord. Because whatever fall from your lordship, my lord, being a citizen of this country, my lord, I also told that one shouldn't be disturbed with this
Yes.
beating of drums.
Probably you give
It has to
permission
be.
for 2 hours in the morning and then 2 hours in the evening. After 6 or 7 p.m. it should not happen.
But only that, my lord, on the 10th day of the, that is the day of Muharram, which we call 10th day of the month, that is that it falls on 29th of July. That beating of the drum may happen for 4, 5, 6 hours, because that is the day of the Muharram, my lord. That is 29th of July.
Or on Saturday.
On Saturday.
My lord, it is not. It is continuously beating. Yesterday it was happened till 1 o'clock.
That should not
Midnight.
occur. That should not occur.
This is happening, my lord. Day before yesterday, I called up just because of that. Tomorrow, yesterday I was waited. Maybe PS will do something, will stop this nuisance, but no one came to stop. Even I just want to share one photograph, my lord. On 18th of March, that time, higher secondary examination, board examination was going on, and counselor organized blood donation camp where DJ was running throughout the day and night.
For blood donation. DJ's music is there.
Yes, lordship. The disco light. Yes,
Possibly
my
this
lord.
is of March. I don't know. This is not
On
related to
18th,
this.
Then, my lord, the mayor was. My lord, I had given one complaint. I had. My lord, I tweeted.
Pollution control board is not doing anything. March মাসে হচ্ছে এটা।
Bad by limit है ना।
Book you get.
It is still clear.
কি
Print out you can get it here.
अरे
কোন
কি judgment
কোন
কি judgment
judgment
বলো না। কি judgment বলো বের করে দিচ্ছি।
He is in second floor. You can't get it from here.
কোন judgment?
কোন judgment দেখো না একবার দেখো।
AR 2000 SC.
773
বলে AR আছে?
Because this India canon, at times we can't, there's some sentences will be missing.
I have
My
the
lord,
AIR software. I've forgotten the password.
my lord, DJ in marriages is very common.
No, don't expand your argument. You are now concerned about indiscriminate beating of drums throughout the day. That's your concern. That alone.
throughout the day and night, and
Day and night,
not only that, my lord,
Huh.
it is the cooking, in open area, it's going on. Large, huge utensils are using in front of our house, and they are making noise, they are making gathering. Every day this is happening. PS is not at all coming in interior, my lord.
No, no, no. Not that.
This is Somo
If
আছে,
you scroll up, scroll up.
এবার কেন চলে
Just
যায়?
now she's,
আমার তো কিছু বলারই নেই, তো স্টেট করবে যা
no, no, you open the other screen. Just now the citation was there now. No, previous page. Wait.
এটা দিয়ে দিতে হবে চোখে
This one, the AAR online. Wait. Yes.
আমি আমারটা খুলে দিয়েছি।
বের করে দেন। What does he want to do?
Oh, you won't get, you have to buy it to download, you see, all right. All right, then open that India canon itself.
চলে গেল।
One second. Please come. By this public interest litigation, or public interest writ petition, the petitioner appearing in person seeks for certain directions against the respondent police. The concern of the writ petitioner is that there is severe noise pollution in various parts of the city on account of continuous beating of drums by a group of persons throughout the day and night. On the alleged ground, they are celebrating the festival of Moharram.
Begin the celebration, we can begin the order.
The petitioner would state that there is a ban for azan
We can't do
by using loudspeakers and for the loudspeakers and for the last 5 minutes only, which is certainly a religious matter. But the non-stop beating of drums with no restrictions of the intensity of the sound is illegal. According to the petitioner, the noise pollution is a serious threat to public health and welfare. It creates a stress and would affect the persons who reside in and around the area where this beating of drums is being done throughout the day and night. The petitioner would also state that there are school-going children. Many of them have to
What's 62?
take their examination. There are senior citizens, people who are sick and ailing, and all of them have been affected. And in spite of repeated complaint lodged by the appellant before the third respondent, by the writ petitioner, before the third respondent police, no action has been taken. With these facts, the petitioner seeks for appropriate directions to stop the nuisance caused on account of the continuous beating of drums. The learned government counsel appearing for the respondent would submit that whenever the petitioner has approached the respondent police, her grievance has been looked into and appropriate action has been taken. And the beating of drums and the period during which the beating of drums is permitted he has been regulated. The petitioner, by way of reply submission, would state the stand taken by the respondents is factually incorrect, and beating of drums is continuously going on, and there is high noise pollution. After we have elaborately heard the learned advocates for the party and hearing the petitioner in person and the learned government counsel, we have to point out that that the Honorable Supreme Court, in the decision in the case of Church of God, within bracket full gospel, in India versus KKR Majestic Colony Welfare Association, reported in AAR 2000 SC 2773, the Honorable Supreme Court was considering a similar issue, a somewhat similar issue relating to noise pollution on the ground of religion. The question which fell for consideration before the Honorable Supreme Court was whether beating of drums or reciting of prayers by use of microphones and loudspeakers so as to disturb the peace or tranquility of neighborhood should be permitted. The Honorable Supreme Court held that undisputably no religion prescribes that prayers should be performed by disturbing the peace of others, nor does it preach that they should be through voice amplifiers or beating of drums. Further, it was pointed out that in a civilized society, in the name of religion, activities which disturb old or infirm persons, students or children having their sleep in early hours or during daytime, or other persons carrying on other activities cannot be permitted. Further, it was pointed out that the young babies in the neighborhood are also entitled to enjoy their natural right of sleeping in a peaceful atmosphere, semicolon. A student preparing for his examination is entitled to concentrate on his studies without there being any unnecessary disturbance by the neighbors. Similarly, old and infirm are entitled to enjoy reasonable quietness during their leisure hours without there being any nuisance of noise pollution, aged, sick, people affected with psychic disturbances, PSYCHIC, psychic disturbances, as well as children up to the age of 6 years are considered to be very sensible to noise, and their rights are also required to be honored. The Honorable Supreme Court took note of the provisions of the Environment within bracket Protection bracket Close Act 1986 and the rules framed thereunder for noise pollution level, which prescribes permissible limits of noise in residential, commercial, industrial area or silence zone. The Honorable Supreme Court took note of the decision of the High Court of Madras in Appa Rao MS versus Government of Tamil Nadu and another, 1995, 1 LW, Law Weekly, page 319 within bracket MAD, Madras, wherein certain guidelines have been laid down for controlling the noise pollution. The division bench of the High Court of Madras, after considering the contentions raised by the parties and the decision cited, and also the relevant provisions of the Madras City Police Act 1888 and Madras Town Nuisance Act 1989, issued directions to the government for controlling the noise pollution and for the use of amplifiers and loudspeakers. The court also, the Honorable Supreme Court also took note of the articles which appeared in the ICMR bulletin of July 1979 containing a study on noise pollution in South India, wherein it is pointed out that noise pollution will lead to serious nervous disorders, emotional tension, leading to high blood pressure, cardiovascular diseases, increase in cholesterol level, resulting in heart attack and strokes, and even damage to fetus.
অর্ডার দিলে আবার কি বলবো?
In the said case, the appellant was a church. And the allegation was that on account of use of loudspeakers, there was a nuisance caused on account of noise pollution. The Honorable Supreme Court pointed out that it cannot be said that the religious teachers or the spiritual leaders who had laid down the tenets, TENETS, had anyway desired the use of microphones as a means of performance of religion. Further, it was pointed out that one can practice, profess and propagate religion as guaranteed under Article 25 within bracket 1 of the Constitution, but that is not an absolute right. Full stop. The provisions of Article 25 is subject to the provisions of Article 19 within bracket 1 within bracket small a of the Constitution. And on a proper construction of the provisions of Article 25 within bracket 1 and Article 19 within bracket 1 within bracket small a of the Constitution, it cannot be said that the citizen should be coerced to hear anything which he does not like or which he does not require. The ultimately
যদি এটা যদি ফার্স্ট থেকে যা বলতে পারবে সেটা বলে পিসিবি তো রেগুলেটরি অথরিটি এটা পুলিশকে এনফোর্স করতে হবে তোমার অর্ডার।
No, just I would get and say. The Honorable Supreme Court also referred to the observations made by the Constitution bench, rights under Article 25 and 26 of the Constitution in Acharya Maharaj Shri Narendra Prasad Ji, Anand Prasad Ji Maharaj versus State of Gujarat, 1975, 1 ACC, page 11, where the Honorable Supreme Court, after considering the various contentions, observed as here under. Sir, it is in para 12 of the judgment. I will mark with pencil, thereafter you rub it off. No rights.
My lord. My lord, may I, my lord? Well, my junior, may I take it? Junior, may I take your lordship's leave?
Yes, yes.
I'm deeply.
There is some role for the pollution also. We'll indicate in the order.
Then I'll stay. Then I'll stay.
In the aforementioned decision, the role of the state has also been clearly delineated. And it has been pointed out that the state has to step in to set right the imbalance between the competing interests. Ultimately, the appeal filed by the appellant before the Honorable Supreme Court, namely Church of God, within bracket Full Gospel in India, was dismissed. In our considered view, the decision of the Honorable Supreme Court would apply with full force to the grievance expressed by the writ petitioner in this public interest litigation.
ঝামেলা লাগিয়ে দেবে না ভাই আমাকে দাও থোড়ি অমিত দাস নেই
না আমার তো দিয়ে মামলা ধরে নিয়ে যাওয়ার
কারণ
আরে
আছে
আমার বন্ধুর সাথে বুঝতে পেরেছি আমার তো বন্ধুর বাড়ি নিজের পার্সোনাল মামলা ধরে দিয়েছে
তো বড় সড় অর্ডার হয়ে গেলে কালকে আমার বাড়ির বাইরে সবাই দাঁড়িয়ে যাবে
As observed by the Honorable Supreme Court, that even though the rules are unambiguous, there is lack of awareness among the citizens as well as the implementing authorities who will be the respondent state as well as the pollution control board.
এটা দেখিয়ে কালকে পুজো
It was further pointed out that
পাগলারা কম নয় এবে
the implementing authorities are duty bound to implement the rules. And ultimately, the direction issued by the High Court was affirmed. This one you add and then say this decision is fully applicable. As pointed out by the learned counsel appearing for the respondent state, that beating of drums may be part of a religious activity during the festival which is to be celebrated on 29th July 2023. However, unabated beating of drums is impermissible in terms of the relevant rules as well as in the light of the observations and directions issued by the Honorable Supreme Court. The petitioner had earlier filed a writ petition before this court in WPA 23366 of 2022. And by order dated 28 and an order was passed on 28/10/2022, wherein the learned single bench has referred to a notification issued by the state of West Bengal in notification number EN/334/6/6 dated 29/12/2009, according to which loudspeakers cannot be used in open area after 10 p.m. And for the use of microphone in open area, sound limiter should be attached to the amplifier. It is not clear as to whether the respondent police are aware of such notification. It was the duty of the West Bengal Pollution Control Board to issue public notices prior to any religious festival or any congregation or any rally or meeting, sensitizing the citizens that about the relevant rules which prohibit indiscriminate noise pollution. If what has been said by the petitioner is true, namely that the beating of drums is continuing day and night in the area where she resides, as well as in other areas within in Kolkata, it is undoubtedly illegal and contrary to the relevant rules. Therefore, there will be a direction to the respondent police to immediately issue public notice regulating the timing for beating of drums. On earlier occasions, this court has considered the various notifications issued by the government granting permission for conducting processions and rallies, whereby a organization or a club has to approach the relevant authority, the concerned authorities, and submit an application form with necessary declarations and furnishing relevant information. And only after permission is granted, such an organization can take out processions or conduct rallies. It is not clear as to why such a measure has not been put in place so far as the complaint made by the petitioner with regard to beating of drums throughout the day and night. Therefore, the respondent police, the respondents are directed to, the respondents 1 to 3 are directed to immediately issue public notice stating that organized groups which want to perform the prayers, which according to them would include beating of drums, necessary permission should be obtained. And such permission, if granted, shall be for an identified group, and the location can also be fixed while granting permission. Apart from that, the time limit for during which the beating of drums can take place has to be specifically mentioned. The petitioner would further submit that the people in the locality have installed open air kitchen right in front of our house and using huge vessels are cooking food day and night. It is not clear as to why the third respondent police has permitted such open air kitchen, especially when the petitioner alleges nuisance to herself and to the members of the family, her family and the neighborhood. This aspect also has to be regulated by the respondent police. The West Bengal Pollution Control Board is directed to immediately issue a public notice and give wide publicity that the noise level cannot exceed the permissible decibel as laid down in the relevant rules and the notification, and also make it clear that any violation thereof would invite penal action under the provisions of the pollution control laws. The above directions shall be complied with effectively and its letter and spirit without any deviation.
But only one difficulty with regard to this notification, with regard to taking out the procession, and they have to seek permission. The festival is day after tomorrow.
Within 12 hours, you can.
Because
this thing, what your lordship said, I bow down. But my lord, these questions.
We will send 3 groups near your residence.
I'll tell you, I'll answer you, lordship. What has happened is, my lord, first of all, as far as this, what I could hear, my lord, as far as the cooking is concerned, my lord, that I really don't know whether there's any such thing happening. I'm coming to the beating of drums later on, but as far as this cooking concerned, we have not got any information. My lord,
you make an inspection.
So if you're not
one patrol, if it goes.
No, and that is what I will do that. Only thing that is not a problem.
If you want, you can do. If you want, you can do. You still don't want to do.
No. But the next thing is, my lord, we have coordination meetings with the different.
So therefore, let us assume there is 3 clubs in an area, 2 associations. They will give a small letter saying that we have organized 10 people will do it. All right, you are permitted to do between this time and this time. The decibel level shall be. They are not leather drums. They are metal drums. They are metal drums.
No, metal drums.
Is it right?
No.
Yes, Lordship, it's a metal.
They are metal drums.
Lordship,
You
just
see the
have a seat in the
photographs?
pigs. And
You have seen those dole.
Yes.
it's a metallic drums. Yes, Lordship.
I'll tell you, lordship, over here.
Metallic drum, it does not even require a microphone.
What I'm
It's not only one.
submitting
It's
is
in group, my lord.
only slight modification. We shall fix a time frame within which they shall do this.
You can read that.
Instead of that notification and application.
No. Public notice you have to give.
No, public notice will give. That is not what I'm saying. I'm only saying that application part. Because today application is so 2 days are left.
Public notice regulating the time for beating of drums. No. On earlier occasion, this court has considered the various permission for conducting protest whereby an organization or a club has to approach the concerned an application form with necessary declarations and information. And only after permission is granted, such an organization can take out provisions or take values. It is not clear as to why such a measure has not been taken
It's a metallic
the
drum.
complaints made by the petitioner.
Then we have said direction is there. No?
পরশু দিনের পরশু দিনে আমি কালকে
immediately issue public notice as mentioned above, and if feasible can also identify
Yes.
the groups if feasible,
metallic.
and if feasible can also identify the groups which can be permitted to to carry on beating of drums by maintaining the permissible noise level if feasible.
But your lordship is,
We have not given specific there. We have made an observation. Sorry, we have observed that the respondents shall do so if feasible, bearing in mind that the festival is to be celebrated on 29/7/2023, and within the short time, it may not be feasible for the authorities to invite applications and grant permission. However, a standard operating procedure within bracket SOP in this regard shall be drawn before any other religious festival or meetings or rallies are conducted where DJ music is being played and beating of drums and other musical instruments are being used.
I was only on that applying for
Madam,
public.
may I
That
make-
will not too short a time. is
May I
there.
make one?
Other one that we will not already have a SOP. We will.
You are not able to implement, accept it.
No, no.
Madam,
You are
may-
not
We
able to
will
implement.
try to. That's all we can say.
Madam, may I make one submission? But if your lordship kindly takes page 21 of the writ petition,
Huh.
lordship will find that, my lord, this is my lord, our forwarding memo
Correct.
pursuant to a complaint to the police. Now, my lord, I have no qualms in.
You don't have, sir, what the problem is, the pollution laws are very powerful.
Yes, absolutely.
It is like a, what is an automatic weapon. But you don't have bullets.
So that is, I tell your lordship, only one thing,
Your law is very stringent, but you don't have the machinery
that's
to
right,
enforce it.
correct, absolutely correct.
Your
Absolutely.
officer, your assistant pollution control officer, he'll be beaten black and blue if he goes there, saying that stop.
So therefore, I have to have the help of the implementing agency. Now, my lord, I tell your lordship, only one submission.
Yes.
Only one submission is making, my lordship. I have no qualms about this. This is the statutory reports, it has to be done.
The page
Page
number,
21, lordship will find, my lord, we have forwarded it. 21 is the latest, 20 is also there, but 21 is the latest.
2022 এর লেটেস্ট আবার কোথা থেকে
এই 21 ভাই, আরো দাঁড়া না।
2021
ও, আমি কি তোর against এ বলছি, আমাকে বলতে দে।
2021
এই কথা না শুনে তাহলে
you see what they have said.
No, no, I've just forwarded the
Must be
complaint. No, no, what I was submitting is this, my lord, the time being of very short. My lord, lordship has directed us to make wide publication. My lord, if your lordship keeps that limited to the area concerned in the petition. Because all over the state, my lord, because
In between you can add, it is noteworthy to point out that the officer, that the
এই যে
West Bengal Pollution Control Board by
21ই তো
letter
বলছি,
dated 8/7/2021
পুরো স্টেটে করতে পারবো না।
has forwarded a complaint with regard to noise pollution for playing of loudspeakers at Nawab Ali Latif Street, Kolkata 16,
স্ট্রিটটা শুধু বলেছে।
to the officer in charge, Park Street Police Station, comma the third respondent. But enclosing a copy of the complaint sent by the writ petitioner with a request to the police to ensure that the following points are complied with strictly in conformity with the provisions of the noise pollution within bracket regulation and control bracket close rules 2000 as amended, and the orders issued by the National Green Tribunal from time to time. The points being as hereunder, page 21, sir, italics. Thus, the respondent police has been made known of the relevant statutory provisions which they are bound to take into consideration, and the same cannot be ignored by the respondent police. With the above observations, the writ
আমাদের
petition is
point of
dismissed.
your lordship will kindly record that we have held a coordination meeting with the organizers. My lordship will
You
kindly
do
record.
something.
Your
Sir,
lordship will kindly record.
You show a visible change, sir. You show a visible change. They will definitely fall in line. And this group, the seniors who are there, that's what the Supreme Court says. No religious tenet says you do this,
No, no, this is not there.
and the seniors will never approve of it. But this is some,
Well, speaking for myself, this is not backed by the holy scriptures. I know that for sure. But my lord, it has tremendously decreased now.
with
What
this
I- what
order,
I
you
have
try
s-
to regulate it.
What I have witnessed when I was a kid and what I am witnessing now, it is tremendously
Still a kid.
decreased.
My lord, it is
With-
not decreasing. It is
No,
increasing
no,
because
no,
it's
no, no, no,
metallic.
no. With the increase
Metallic
with the
drum
increase
is
in
using
education, it
nowadays.
has.
What happens is,
Ah.
technology has improved.
That metallic drum.
See, metallic
We've-
drum has got
Ah.
sensors inside and they are battery operated. And all that you need is to hang a loudspeaker in the shoulder. That's all. That is also Bluetooth operated. There is no wire
Yeah,
required.
I've seen that, my lord. And
Technology has gone
my-
far and wide, sir.
my lord, on the back street of the locality concerned, my lord, this Park Street. On 31st of December, my lord, the entire night, these metallic drums are beaten.
No, New Year's Eve has been regulated because I have also dealt with matters where all this revelry has to stop and lot of roads, the movement of 4-wheelers, 2-wheelers is completely restricted. The beats and parks are closed before 11 o'clock, 10:30, 11. And all the hotels, pubs, etc. are also closed. So it can be like what was 10 years back, it's been regulated.
Regulated. It's legal. That's what I'm saying.
My lord, I have,
That's all. We have heard you, madam. We have passed orders.
Well, that aspect of the white publicity is there.
Yes, yes, yes. You also do something.
Yeah, go to the.
No, incidentally, what I say, this matter, I appeared as an advocate for the church.
Your lordship, may I make a request that this judgment be reported as early as possible? It will come to all our aid. Because I have faced this tremendously in my own area. And
As soon as they transcribe it, we will sign it. And immediately it will be up.
lordship, not just on the server, let it be reported, your lordship, in any of the journals. Your lordship's.
That I
That
don't
will
know.
happen only next month possibly. Before that, a journal.
Yes, next month, as soon as it can be done.
Grateful, lordship, grateful.
Serial number 3.
This is my opinion and application for state. The contempt is tomorrow, Millard. Millard, Lordship heard the matter once. Millard, papers were not in order. Millard, the contempt is tomorrow. This is the urgency, Millard. Millard,
What is the direction issue?
Millard,
Without prejudice to the rights in the appeal, you comply with it.
I have done so. I have done so. Millard, complied with
But
the direction.
unfortunately,
Yes, without prejudice to the rights and contention of the order to give him a hearing, I have done so. Now, Millard, a supplementary affidavit is filed asking for further compliance. That, Millard, actually it is what? My case is, Millard, according to the financial institution, my learned friend's account has become SMA 2, that is special mention account 2, as of 29th of February, Millard, 2020.
no, what do you want? You want him to be wound up or you want to settle the matter?
Millard, he is not entitled to further finances, Millard, as per the scheme.
But can you not?
I can't, Millard. Today he is an NPA. Millard, proceedings are pending before the Millard
Suppose
DRT.
he comes forward with an offer.
Millard, that is not his case. The case is, Millard, there is a pre-approved loan, Millard, called ECLGS.
All right, we'll fix a date. We'll fix a date.
Millard, let him not proceed with the content.
No,
I have
certainly not.
Then I proceed.
Millard, your lordship will kindly appreciate one thing.
Yes, please. I have not finished, my dear friend. I have not finished. You'll have your say. Don't be so agitated.
Accordingly allowed, directing the third respondent financial institution
Yes,
to consider grant of benefit of ECLGS.
I have done so.
You have
Now
done
the order to
to the petitioners in terms of the resolution framework
Yes,
circulated by RBI
yes,
and guidelines published by NCGTC.
yes.
Full stop. The eligibility of the petitioners shall be considered in accordance with so and so, which would apply to the petitioner's case. So if you have granted the benefit, this consideration you need to do.
I have done the consideration. I have given him. I have held him. He's not entitled to.
Where that order, he can challenge it.
He can challenge in filing a fresh writ petition. That's Millard, how Millard, the Honorable Supreme Court is saying, Millard, if
That
you
will
send
give
it
a
for
separate grounds has to be raised.
yes,
Okay.
he has no appeal, Millard. Millard, he said that I want money under this scheme.
Sir, can you, Mr. Bose, can you challenge that order which he has passed?
My lord, if I may just indicate, my lord. In the writ petition, based on the affidavits filed by the parties, the learned judge came to a specific conclusion on facts
that I was eligible.
Therefore, that
So,
is the good ground to quash that order.
so, my lord, if I have been held based on their documents that I was eligible under the scheme,
Yeah, true, sir.
yes, my lord.
Justice Ravi,
That is one of the grounds to say hold that this present order is not tenable. But then it will require additional grounds to be heard because that was not subject matter of this appeal.
No, my lord,
This
may I just say this? Possibly I have not been able to make myself clear. We went and filed a writ petition. The original scope of challenge in the writ petition, one of the challenges in the writ petition was that despite me being eligible under central government emergency credit line guarantee scheme, which is a automatic mechanism for disbursement, this financial institution has not disbursed. So, my lord, they in their affidavit raised the issue that whether I was eligible or not. My lord, based on the documents, which is a section 13(2) notice issued by them under the Securitization Act, the court came to a specific conclusion that I was entitled under the scheme for disbursement. So they are in appeal from that order.
Well, that has been clarified
Now-
subsequently. My learned friend should be candid.
The ultimate
Who is
direction- no,
supposed to be candid? I'm not being able to understand.
Para, let us, we can't hear the appeal today.
Yes,
Para 24 says,
my lord.
the eligibility of the petitioner shall be considered in accordance with the relevance so-and-so and resolution framework, which would apply to the petitioner's case.
Correct,
So
my
the
lord.
consideration, it gives them a window. How do you say? Otherwise, the court would have said, issued a positive mandamus saying that do that.
Do that.
They didn't do that. The court said you consider it in accordance with. He considered passed a wrong order according to you. You challenge that order and come.
I will.
We will
I
keep
will.
the appeal pending.
Very well.
Ah,
Very well.
But at the same time,
In terms of the directions issued by
different
the.
figure.
My lord,
From
this
their
is
affidavit in
the
opposition.
order passed in contempt. The honorable single judge in all fairness has clarified para 24. Only you have to consider as per para 24. In all fairness, she
In
has done
terms of the directions issued by the learned single bench. in the
That's
ensuing
page
orders,
7.
The eligibility of the respondent writ petitioner was directed to be considered in accordance with the relevant ECLGS and resolution framework, which would apply to the petitioner's case. Pursuant to such direction, without prejudice to the rights of the appellant in this appeal, the learned advocate for the appellant submitted that the direction has been complied with and an order has been passed holding that the respondent writ petitioner is not eligible.
This is the order. You may hand up
By
the
order dated. dash.
Lord, order of the contempt, Lord, is dated 26th of June 2023 and my order is 28th of June
28th of June 2023. The order dated 28th of June. Since this order is a consequence, is consequent upon a direction issued in the writ petition, it is but appropriate for the writ petitioner to challenge the said order in the manner known to law before the appropriate forum. However, this appeal shall be kept pending, leaving it open to the respondent writ petitioner to question the correctness of the order dated 28 June 2023 before the appropriate forum. Now what will happen?
I'll tell you. Will hear out, Lord. Tomorrow is the contempt. So I have purged the contempt. And this will be my case before the contempt court.
You can tell the court.
I can say I have purged the contempt. Lord, if he has I'm carrying the authorities. Lord, if there is a direction for consideration, Lord, the authority will apply independently and Lord, give that I have done so. He has a fresh cause of action in the writ petition.
The learned advocates for the parties are
closing statements which are not matching with what they have filed.
Are at liberty to challenge it, place this order before the honorable single bench.
I have done so, Lord. She has given directions of filing affidavits. The matter is returnable.
Which is the hearing CPAN 812 of 2020.
Great.
List the matter after 3 weeks. You give a date.
My lord, only difficult. If I may just indicate, my lord, this will completely dilute the issue. I'll tell your lordship why. Because your lordship looked at para 24. My lord, there are two paragraphs 16 and 18
where it says you are eligible.
Eligible.
That has to be decided.
Specifically
Because she
holds
was
that I was
conscious.
eligible.
You need to
Holds.
preserve that finding. You
Yes.
need to preserve that.
She
Yes,
was
yes.
conscious and my lord contempt order, my lord
That is why
8-7.
we have not said anything
Yes.
about that.
Contempt order she
Contempt is coming
clarifies.
tomorrow, let it come,
All fairness she clarifies as per only para 20.
please. Next.
Gratefully.
Serial number 4.
May I get the server copy, my lord, by today? May I get the server copy by today so I
My
can
lord,
show?
today, my lord, kindly appreciate, he is trying to circumvent the contempt proceeding. Now, if he is in contempt, he is in
I am
contempt.
not in contempt.
We have not
I'm
said
saying so.
anything.
Lordship has not said anything. Well, I'll show. Let us go back and.
My lord, may it please your lordship, my lord.
Yes.
This is my lord directed against my lord an order passed by the writ court. Now, my lord, the compass of this writ petition, when my lord it was before the single judge, was my lord brought, my lord. Now it has narrowed down to my lord point of law only, my lord. Now initially, my lord, we moved the petition, writ petition before the learned single on 3 points, my lord. There was a point of bias, there was a point of violation of natural justice, and my lord, there was a point of quorum non-juris. Now, my lord, here, my lord, although the enforcement directorate has started the case long time back, my lord, suddenly, my lord, there was a search and seizure and certain devices were confiscated. Now, my lord, we said, my lord, that this confiscation and the data extracting has to be, my lord, done by independent agency. Well, there is also an order by another single judge in this regard that the data of these devices has to be, my lord, extracted by a expert agency. Well, thereafter, the proceeding under section 17(4) started by the ED. Well, thereby the fact is these devices where, my lord, has to be taken into custody of the ED. Now, in this regard, my lord, we have taken a point, my lord, that there is a point of quorum non-juris, because the Act says, my lord, the adjudicating authority has to be formed by, my lord, one judicial member, one technical member, and one financial member. Now, the fact remains, my lord, although at one point of time this adjudicating authority was formed by all 3 members, my lord, thereafter, when the matter was taken up, was taken by reduced to, my lord, only one member, that is the financial member. So, in that backdrop, the matter was heard.
But the chairman is present.
Chairperson is the only person, he is there.
But this identical issue was considered in Sampath Kumar case.
Yes.
By Supreme Court. That was a case where the administrative member, whether he was entitled to dispose of matters. It said, but once a judicial member or a chairperson is there is discretion vested with him to.
Well, a judicial member was not there. Only the financial member was there. Now, my lord, what happened?
Chairman is a judicial.
The financial. Now, my lord, we are in a better footing. Why, my lord? Because now that single person has also resigned, and there is now
the point of view.
Well, lord, I say that the authority cannot.
No,
authority
you raised it before it. It is not a block development officer or a Tahsildar. So it is an adjudicating forum. And you say that you please rule on your jurisdiction. Preliminary objection. How many times you are saying that you can't hear the matter because you don't have determination? So we will rule on determination. No, sir, please read the. Or I say, no, I don't know. He will decide.
My senior is also there, my lord.
No, he is busy. Parliament session has started. You can't disturb. After 20th, he is fully busy.
The problem is probably.
No, that will be proper, sir. Yes, sir.
I can't see the code.
Sir, you're not. There's some problem in the audio.
Code is visible. Anyway, let Mr. Nag continue. He's doing well.
He is doing well. So senior will be here. You can continue.
Well,
So-
kindly have a look at the act itself. No, why I similar, I will also rely on Supreme Court judgment that without judicial member, my lord, the adjudicating authority cannot function. My lord. Kindly have a look. Kindly have a look, my lord. I will not take much time, my lord. Kindly have a look, my lord.
Sir, there are decisions. The latest is Madras Bar Association is there.
Yes.
R. Gandhi is there. L.
Yes,
Chandra Kumar
I
is
have
there.
all the judgments.
Sampat Kumar is there.
I have all the judgments, but today, my lord, I will rely on a judgment in respect of this only, in respect of PMLA Act. How it has to function, Supreme Court has clearly dealt with that.
Now, at which stage of the matter you came before the High Court?
My lord, at the initial stage, at the initial stage,
No, no, under the Act, proceeding initiated.
Correct.
At what stage of the matter you came here?
Well, this is a stage of 17.4, section 17.4. Lordship, kindly have a look at 17.4, section 17, subsection 4. My lord, kindly have a look. The authority, well, may I place it, my lord? 17.4.
Yes.
The authority seizing any record or property under subsection 1 for freezing any record or property under subsection 1 shall within a period of 30 days from seizure or freezing, as the case may be, file an application requesting for retention of such record or property seized under subsection 1 or for continuation of the order of freezing served under subsection 1 before the adjudicating authority. Now that has to be done, my lord, before the adjudicating authority. Now, my lord, kindly have a look at, my lord, section 6, my lord, all the, my lord, contention of myself and, my lord, the dispute or differences is, my lord, revolves around, my lord, the interpretation of section 6 and, my lord, a judgment passed by the Honorable Supreme Court, whereby it says, my lord, the judicial function cannot be encroached by the executive. If there is a judicial member, has to be there.
No, action was taken by the appropriate authority under subsection 4.
Subsection 4.
And what is the remedy under the Act? Are you entitled to file an appeal
Yes.
before the tribunal?
Before the appellate authority.
Appellate authority.
Before the appellate authority.
Under
Now-
which provision?
My lordships. In section there, please. Kindly grant me a moment. It has to be, my lord, it starts with, my lord, chapter 4 is the appellate provision. Section 26 is appeals to appellate tribunal.
Yes. Save as otherwise provided. No, 25 is appellate tribunal constituted under subsection 12 of the SAFEMA. Shall be the appellate tribunal for hearing appeals against orders of the adjudicating authority and other. Whether this is an order, has he passed an order?
No, not yet. Not yet. My lord, I say.
No, whether the authority under the Act, has he passed an order against which you are entitled to file an appeal?
Not
He
yet.
has not yet done so.
Not yet done so. My lord, the proceeding started. I have filed rejoinder. I have filed objection. They have given rejoinder. The matter is supposed to be heard on 1st of August, as for me.
I think I didn't make myself clear. Subsection 4 gives a power to the authority to seize records and properties and freezing of the records properties, and it shall be done within 30 days of such freeze. Has he passed an order? And
Ballot will kindly see section 8, subsection 1 and 2. This is application under 17.4. After that application, order will be passed under section 8, subsection 1 and 2.
Adjudication.
On receipt of a complaint under subsection 5 of section 5, or an application under subsection 4 of 17, or under 10 of 18, if the adjudication authority has reason to believe has committed an offence under section 3, or in possession of proceeds of crime, he shall serve a notice of not less than 30 days on such person calling upon minister so and so, which he has taken so and so. To show cause why all the such properties should not be declared to be properties involved in money laundering. So whether this notice has
Now they are after 2. They are after subsection 2.
Shall, after considering the reply, if any, to the notice issued under subsection 1, hearing the aggrieved person, take into account relevant material before and thereafter pass an order, record a finding whether all or any of the properties referred to in the notice.
Correct. So he will pass
are
an
involved
order.
in-
So he will pass an order. Then my lord kindly come to section 26, subsection 1.
Any reporting entity aggrieved by an order of the director made under subsection 2 of section 13.
No, 26. 1, my lord, I am saying.
1. director or any person aggrieved by an order passed by the adjudicating authority under this act
May
may
prefer
prefer an
appeal.
appeal.
So we are now at the stage of application under section 17(4) was in issue, has been filed. Thereafter, a notice under section 8, subsection 1 has been issued by the adjudicating authority,
Very good.
calling them to show cause as to why these seized properties shall not be retained.
Yes.
They have submitted their reply.
Very good.
We have submitted our rejoinder.
Ah.
Opportunity hearing was given.
Hmm.
There was initially some dispute on their part for the place of sitting of adjudicating authority, the document, rejoinder, copy not served. Those have not been carried in this appeal. Now we are at the stage where in terms of the order passed by this honorable court, honorable single judge, the hearing was again fixed. After that,
Very
fresh opportunity of hearing was given.
Yes.
So we are at the stage of
Because
hearing.
that is a statutory requirement.
Right. Earlier also granted. So in terms of the order, we have further granted to both of us. So we are at that stage. So the year after, the adjudicating authority will pass an order under subsection 2 of section 8, which is appealable. What your lordship was wanted to know, that we are at the stage now at adjudication.
So yes.
Now
yes.
here I say,
Ah.
this adjudicating authority has not been formed, established under the
Yes.
statute.
Let him rule on his jurisdiction. You have to rule on your
Malad,
jurisdiction.
I
It has
say-
already,
Malad,
with the deepest respect, Malad, it has already been
Malad,
ruled
I
by the
say-
honorable
I say,
single
Malad.
judge, as well as by the honorable Delhi High Court also, which has been
Malad, I
relied
will-
upon by the honorable
I
single.
will try to satisfy your lordship on the issue, Malad. I have also been prepared, Malad, with judgments. and
No,
everything.
then it is
Malad, kindly have a look at section, Malad, for
actually you have unnecessarily invited an adverse order.
Malad, not Malad. But if the
It is unnecessarily.
Malad, if
It's an adjudicating authority. You have to first tell him, sir, you are not being constituted in terms of so provisions of the act. Therefore, you are forum non juris.
quorum non-juris.
Quorum non juris, or you cannot adjudicate the matter. Then he will pass an order. You have to ask him to decide that as a preliminary issue. You are doing that before a civil court.
Lordship.
You have
Malad,
unnecessarily rushed to this court and invited an
Malad,
adverse order.
may I just.
We'll fix a date for the appeal, sir. There's no urgency. Lot of
Malad,
people are
Malad,
like
only, Malad, Malad,
white collared people.
Malad, one thing, Malad. Matter is fixed for hearing on fast.
You participate without prejudice to your rights.
Malad, not to pass any order, Malad, I will participate.
Well,
Malad,
that
I-
is their, that
Malad,
is their
We will
only
tell
attempt.
that the writ petition it's premature, or you can do one thing. You can withdraw the writ petition. We will vacate, or we will say that
Malad,
this,
writ petition has been displayed on the
we will permit you to withdraw the writ petition in this appeal. We will vacate the findings. We will say that you will adjudicate this point before the adjudicating authority. Don't jump the queue. This enactment, at least speaking for myself, as I have dealt with these matters, this enactment has sufficient safeguards. If you jump the queue, then you invited an adverse order. You need not have come to the writ court.
May I come back tomorrow, Malad? Tomorrow, Malad, if matter can retain the position, I can consent and come back tomorrow.
That will be
Malad,
better.
I
Because,
totally.
see, always the question of jurisdiction. He is not, as you said, he is not a revenue authority. He is an adjudicating authority who has been given powers under a particular central enactment.
Lordship.
So presupposes that he will exercise powers of the civil court.
Lordship.
He can summon witnesses,
Lordship.
call for, and he can direct properties to be attached, accounts to be frozen,
Lordship.
and properties to be seized to the assets of the government. He can make a declaration.
Lordship.
So therefore, he has got so much of power to adjudicate your case. And we will say that you can raise this question of jurisdiction before him. He will take it up as first among the several issues.
Lordship. Lordship. Lord, before dealing with the main matter.
Malad, I would invite your lordship to kindly see once that the order passed by the honorable single judge, because it records that it is the, Malad will not take me at time, it is the attempt on the part of the petitioner only to delay. Malad, this is the third time I tell your lordship, 2 revisions before this honorable court, just only to invoke the jurisdiction of the writ jurisdiction and to stall the proceeding. They have taken
It
it
goes
quorum
beyond,
non-
Malad, this, Malad. I have a lot of things to say, Malad.
on the point of
FIR is of, Malad.
Prime facie, we are of the view that you
Lordship.
ought not to have come to the writ court.
Lordship.
You unnecessarily
They just
came here
want
and
to
got
waste the
adverse.
time. And my lord, what is there? The order is only to retain the document seized.
Yes, Malad, that is the problem.
No, the tribunal, see, there are a lot of I don't know, you would have dealt with a lot of cases under this. There are ways and means to get back the document. In fact, after coming here also, we dealt with one matter. We said that application to be moved before the tribunal. And they are on appeal, not Arjit was not on appeal, some other counsel was on appeal against an order permitting release of the documents.
Release of the documents.
Against that they came. We dismissed their case, saying that the adjudicating authority, I mean, the appellate tribunal granted relief in favor of the
Assessee.
assessee or whoever it is. Against that they came. We dismissed the writ petition. I think it's an inter-court appeal. I vaguely remember. We dismissed it.
I will find it out.
And you jumped the queue. You have
Well, at the point, well,
I
we had a,
placed the
well,
order of
my contention,
the order of
Lordship
single
kindly-
judge who has decided on this issue also.
if he wants to withdraw the writ petition, we are going to send him back to the adjudicating authority. Let him argue.
My lord, a law, it's a question of law. My lord,
well, then he had it out, my lord, I
It's
have also a
premature.
question of
We
law.
we will dismiss the writ petition as premature.
my lord, then the findings of the honorable single judge will also go.
That will go.
That will go.
That will go, my lord. I don't want that.
So he don't want, he want to praise the appeal.
No,
Well,
because
the point is simple, my
I
lord.
can show you
But
lots of
the access, well, kindly, my lord, bear me for 1 minute.
See, this power, of course, certain decisions which say this enactment is draconian.
It has to be, man.
There are decisions which say that. Some high courts have said. Some bail orders, they have said it is draconian. So allow him, give him an opportunity. Give him an opportunity.
I have given, my lord, he has pleaded the entire matter. It has been dealt with by
All
the
right,
honorable
at the
single judge.
request of
My
the
lord can
learned
see from
advocate
the
for the
order.
petitioner, list the matter
Tomorrow
on
I said, tomorrow is original side, something, my lord, Monday, my lord.
Monday,
On instruction. Monday.
Monday, on the same position. Do some, or Wednesday it will come. Wednesday will be third, huh? What is it? Huh? It will come on Wednesday. No, you want it on Monday.
Wednesday, my lord, on first, my lord, the matter hearing is fixed. That's why, my lord,
But that is their only motto, not to
No,
proceed with the
no,
matter.
no, I have a very good legal point, my lord, that I believe.
It has been decided already by Honorable Delhi High Court
My lord,
twice.
my lord,
All right.
I
by
will
this
delay your Supreme Court, my lord. It's not the case, my lord, I am delaying, my lord. I have a point of law. I want to my lord, argue that before your lordship. My lord, lordship has fallen from your lordship. I have to take instruction and come back. My lord, the matter is fixed on Monday. My lord, on first. My lord, that's what, my lord.
The matter has been fixed in the meantime for 4 times. I tell your lordship.
So let it come on Monday.
Lordship. I am grateful, my lord. Much obliged.
Grateful, deeply
Obliged.
Serial number 5 to 8.
Grateful. 5 to 8, my lord, I beg to appear, my lord, for the Bengal Energy and Tata Power.
My lord, I appear for the
I am
appellate.
for state lordship. In this matter, Mr. Mukherjee is appearing. He is unable to come to court as he is sick, lordship. I'm praying for a week's adjournment, lordship.
My lord, I appear for the appellant regulator. My lord, where the sole question
But
was.
we modified the interim order.
Yes,
Yes,
modified it.
But my lord has, my lord,
Is-
excluded the solar and other
Other
parts of
parts.
from the
That
notification.
difficulty is no more
We are
there.
only restricted
Now
to
the,
cogeneration.
the final point that lordships are required. to-
Can we have it after 15th August?
Yes, yes.
My lord,
Grateful,
please.
lordship.
All right, a list for directions on 24/8. Next,
Lord, 24th of August, my lord.
Yes.
24th.
Yes, I'm grateful.
Yes. Obliged.
Serial number 9.
My lord, I am appealing for the appellant in this matter.
Yes.
My lord, this matter arises out of nine.
This is an intra-court appeal.
Yes, my lord. My lord, the writ petitioner filed a complaint with the respondent authorities with regard to the candidature of one of the other candidates in a outlet dealership selection. The ground for challenging the candidature of the other candidate was that the candidate, this is a selection process out of OBC candidates. And the ground for challenge was the OBC certificate that was with the respondent, private respondent, was not valid at the date of application according to the rules of the respondent IOCL. My lord, the London Trial Court has been pleased to dismiss this writ application. My lord, at one point of time, the respondent number 7 could not have held 2 OBC certificates. One certificate.
No, normally on the application form, there will be an annexure where he has to obtain. See, suppose the candidate may have an OBC certificate issued by the competent authority.
Yes, my lord.
Along with the application, there will be a format.
Yes, my lord.
In that, they have to obtain a separate, authorization.
My lord.
What is your case?
My lord, my case is from the public domain, from the website of the government, we can obtain information with regard to certificate, caste certificate. That we have already annexed with the writ application. It shows the certificate was issued on 26 December 2018. And the last date for application for the selection process was 25th December, just one day prior. So on the date of application, even if he had
certificate might have been uploaded belatedly or issued, but the fact is whether having been recognized as an OBC candidate,
yes, my lord,
it inures from him from the date of his birth.
Yes, my lord, but the rules of the IOCL that say on the date of application, he should have possessed, my lord, the rule, specific rule is there. That is
the learned judge just said,
45.
OBC certificate enclosed in the affidavit of Indian Oil Corporation Limited.
Yes,
this court is of the view the writ petitioner does not have a case. Certificate annexed to the affidavit of IOCL is an OBC certificate given by subdivision so and so. Clause 17 of the brochure as well as clause C of the standard format indicates a particular format in which the set correct should be, and also the original document together. Clause B so and so. There is nothing to indicate that OBC certificate given by the private respondent did not comply with the conditions.
I was coming to that, my lord. My lord, kindly takes page 156. There is the certificate. I have annexed the affidavit in opposition.
You are only on the date.
Date and also the certificate, my lord. Kindly sees
156. Yes.
156, my lord. Annexure R1 of their affidavit in opposition. My lord, kindly sees on the top there is a number. And after that, performer for other backward class certificate. And thereafter, what is written, my lord? Certificate to be produced by other backward classes applying for admission to central educational institutions, CEIs, under the government of India. This was not a valid certificate to be produced before the IOCL.
No. That's what they are saying, sir. Sir, the certificates, the formats may be different issued by the state government. But where is the application? The application submitted to IOCL.
That
you don't have.
That I
Where is their affidavit in opposition? They have enclosed the certificate.
This is the certificate they have enclosed, my lord. The IOCL has enclosed this certificate. 156.
Then 157.
My lord.
Verification certificate has been issued.
A verification is 157. Now, my lord, the writ petitioner, the appellant herein, had made some applications under RTI to the concerned government organizations. My lord, we got some replies belated subsequent to passing of this order in the writ application, my lord. I have prepared a supplementary affidavit. If my lord kindly allows me to submit it.
Yes.
My lord, in this.
Where is the standard format in the application?
That is at page 78, my lord.
78.
Yes, my lord.
And he has furnished this certificate.
The successful candidate, the
Hmm.
private respondent has submitted that, my lord. Now, so far as after this complaint, my lord, we inquired before the authority concerned, West Bengal state authorities, since they are the appropriate authorities for confirming.
Correct.
And the last annexure which was placed before your lordship, the next page will show that the concerned subdivisional magistrate has certified that after verification, it was found that the date given by the successful candidate is correct and verified. So we relied upon that and we issued the dispute dealership license, my lord. We have to rely upon the state authorities, my lord. We have no.
You are an
mechanism.
unsuccessful applicant.
Yes, my lord. There were two applicants only.
This is enough.
My lord, may I just place the supplementary affidavit? My lord, kindly sees page 4 of the supplementary affidavit. This is an application I filed under RTI. My lord, the second question, whether the said private respondent has been issued any other caste certificate. And on the first question, I have mentioned a number that was available on government portal.
No. He says no.
He says no, no other caste certificate. Now, my lord, the caste certificate produced by the IOCL, that is at page 157, that goes then. That is not there. This is obtained from the office of the subdivisional officer, who is the authority for giving caste certificate, my lord.
All right, you place that before them. As of now, we can't do anything.
As a matter of fact, there is no public element involved in this matter, contractual matters, my lord.
Oh, this is a PIL. So no, it's a
No, not PIL,
not a PIL.
Not a PIL, my lord.
It is
an appeal.
Regular appeal, my lord.
Regular appeal, my lord. Mandamus appeal.
The petitioner, the writ petitioner, being aggrieved by the dismissal of his writ petition in WPA 7941 of 2021, has filed this intra-court appeal. The challenge in the writ petition was to the appointment of the private respondent as a dealer of the Indian Oil Corporation Limited, on the ground that on the date when the application was submitted by the private respondent, he was not a candidate belonging to an OBC community. This issue was considered by the learned single bench and found the learned court on facts has found that the private respondent has produced a certificate issued by the South Subdivisional Magistrate, Sardar Kishan Nagar, Noida. It is submitted by the learned advocate appearing for the Indian Oil Corporation that after the complaint was received from the writ petitioner, the corporation undertook a verification exercise by addressing the subdivisional officer, Sardar Kishan Nagar, and by memo dated 30/7/2019, the said subdivisional magistrate certified stated that the OBC certificate in the prescribed format issued to the private respondent was verified, and has affirmed to the correctness of the said certificate. In the light of the said stand, the learned writ court dismissed the writ petition. In our view, the Indian Oil Corporation having confirmed that the certificate issued in favor of the private respondent is genuine, has awarded the dealership in favor of the private respondent, and no error can be attributed to such action being taken by the Indian Oil Corporation. The petitioner relies upon a reply received under the Right to Information Act, wherein the public information officer has given the answer no to the question within inverted comma whether Kalyani Ghosh, son of Narayan Ghosh of Jahangirpur, has been issued any other caste certificate. Inverted comma close. The question itself has been so framed, seeking information as to whether any other caste certificate has been issued. In any event, the issuing authority himself on verification has certified that the certificate issued in the prescribed format has been verified and found to be correct. Thus, we find no grounds to interfere with the order passed by the learned single bench. Accordingly, appeal fails dismissed. Next.
Serial number 10.
My lord, in this matter, this is Jui Datta Chakraborty is appearing on behalf of the appellant. My lord. She is leading me, my lord. Kindly takes up this matter at 2 p.m., my lord. Because she is arguing one matter before the courtroom number 23, my lord.
What
Can
happened? What happened? Your writ petition was dismissed.
Yes, petition was dismissed with a cost
personally
payable to the police authority amounting rupees 5,100. Dosh. My lord, what happened in? My lord, kindly takes up this matter at 2 p.m. She requested me to, she is leading me in this matter, my lord.
Yes, you come at 2:30.
Keep levelize your lordship.
Pass over.
Serial number 11.
My lord, I am appearing on behalf of the state respondent, my lord.
The matter has been listed under the heading senior citizen. Her son is unable to enter into his chamber before the learned executive magistrate Bardwan. 7,500 rupees cost. We will restore the writ petitions. Some at times, what happens is, petitioner is a senior citizen. Problem is with their son, who's not a senior. But the learned judge is right. Why is 7,000? The petitioner, this appeal has
Regarding the property, my lord, one son, my lord, this is.
we can't decide it in a writ petition. Let it be argued on merits. This intra-court appeal has been filed by the writ petitioner in WPA 2918 of 2023, challenging the order dated 22/3/2023, by which the writ petition was dismissed on the sole ground that the petitioner has misled the court to believe that the writ petition is a senior citizen matter. On going through the writ petition, we find that the writ petitioner is aged, writ petitioner Archana Roy, R-A-Y or R-O-Y, I don't know, is aged 63 years. If that be so, the petitioner, the writ petitioner is undoubtedly a senior citizen. However, it appears that the learned writ court was of the view that that since the appellant writ petitioner is attempting to canvass the grievance of her son, who is not a senior citizen, dismiss the writ petition. In our view, the matter can be decided on merits, and therefore we are inclined to interfere with the impugned order and restore the writ petition to the file of the learned single bench. Accordingly, the appeal is allowed. The order dated 22/3/2023 is set aside, and the writ petition is restored to the file of the learned single bench to be heard and decided afresh. Let the writ petition appear before the appropriate learned single bench in the week commencing 7th August 2023. Next.
Serial number 12.
12, Your Lordship, I'm praying for short passover. My senior is engaged in court number 10.
You are not ready.
No, Your Lordship. Can you fix it at 2:30?
But ground number 2, have you deleted it?
Yes, Your Lordship.
And who will appear for the respondent? Mr. Gaurav Das and D. Chatterjee. You inform them.
Okay.
The learned advocate for the petitioner has carried out the amendment to the memorandum of grounds by deleting ground number 2 in page 3. The learned advocate for the petitioner is directed to give notice to the learned advocate appearing for the state that the matter will be taken up next week, next Thursday. Next.
Serial number 13.
I am the writ petitioner appellant.
I am the respondent.
My lord, the facts in a nutshell, my lord. My lord, after retirement, the petitioner and his wife purchased a flat in the year 2006. There is no relationship with the bank to these petitioners, my lord. Never it was been mortgaged, the flat was been mortgaged. Never any security interest has been created. But I took a point before the, my lord, the writ court that if no security interest has been created, so entire process under the SURFACE Act is bad.
No, but Supreme Court has held any person aggrieved by any act.
May I, my lord. I know, my lord. That is short. That starts from my lord Satyavati Tondo. That my lord start from Satyavati Tondo. But the first judgment is Satyavati Tondo. But my lord, in this case, my lord, is separate.
No, after Satyavati Tandon, it has been reiterated in several decisions.
Several decisions. But my lord, section 17(1), where Supreme Court says, if I am a tenant, if I am a lessee, if I have any dual relationship with the bank, my lord, in all the facts, all the judgments, my lord, I can place, my lord. Then, my lord, section 7, I have a remedy under section 70.
Court cannot go into it. Supreme Court says that assuming it is an agricultural land.
Yes, ma'am.
And you cannot invoke the provisions.
That is section 31.
Yes.
That is section 31.
That is also a question to be decided in an SURFACE appeal under 17.
Because there is a disputed question of fact. If, my lord, after 2006 security interest has been created,
you are losing out on time. You go to the debt recovery tribunal.
But then I am an octogenarian man, my lord. I am a petitioner octogenarian man. But then section 17 is not efficacious, my lord. It's not an efficacious remedy for me. Because, my lord, my lord, why, my lord? I am in a road. I am in a road by the bank. All the flat owners wrote to the bank that the persons they have told the borrower, they don't know him. This is absolute fraud. A fraud can be decided by the tribunal.
Definitely.
This fraud cannot be tribunal whether.
Who's he? He's not a borrower.
No, my borrower, I followed each and every procedure under SURFACE Act.
That property is mortgaged to the bank.
To us, and original deed with us.
Who executed the mortgage?
The person mortgage, his name, his.
After 2006, if it's mortgage is bad. After 2006, I purchased the flat. I have a deed annexed with this. I have an original deed also with.
But probably this mortgage was not reflected in the encumbrance.
So probably what is the fact? So far I can submit, but I will not on record that at the time of construction of building, mortgage was created in the of flats. And after the construction, that promoter has sold to other persons. So once mortgage is always mortgage. So we are.
No, wait, kindly indicate.
He is second purchaser.
If he kindly indicate the date of mortgage, then I am out of court. If you kindly indicate the date of mortgage, if it is prior to my deed or my post of my deed.
13(4) notice issue.
Not to me. Not to me.
You are in possession. It is in qua the property.
I am the owner. I am not only the possessor. I am the owner. Tomorrow, my lord, my property has been my property has been mortgaged by anyone, and my lord, I have been thrown out from my property under the SURFACE Act.
You didn't do the due diligence. You should have.
How could I? Before me, if no deed has been executed, after due diligence, I cannot.
That is a disputed question. The counsel for the bank says.
Only I asked for the date. Before 2006 or after 2006?
You approach the bank, ask them for copies.
Before, my bank is before him, but kindly indicate the date. I will be out of the court. If it is before 2006, prior to my deed, my lord, then I am out of the court, my lord.
We have heard Mr. Devashish.
But kindly, my lord, it's an octogenarian person, my lord, kindly.
This intra-court appeal is directed against the order dated so-and-so in WPA number so-and-so, which was filed seeking for a declaration that the notice issued under section 13 within bracket 4 of the SURFACE Act 2002 is without jurisdiction. The learned advocate for the appellant would vehemently contend that the appellant is the rightful owner of the property in question and he has not created a mortgage in favor of the respondent State Bank of India. The learned advocate for the respondent bank submitted that a mortgage has been created by the developer and the mortgage is subsisting. And suppressing the mortgage, sale has been effected to the appellant. In any event, as rightly held by the learned
The
writ
developer
court,
has not created, my lord.
as rightly held by the writ court, all these issues have to be agitated before the appropriate forum under the provisions of the Sarfasi Act by resorting to the remedy available under section 17 within bracket 1 of the Act. It is the submission of the learned advocate for the appellant that the bank should disclose the date on which the mortgage was created. And if the mortgage was created after the petitioner has purchased the property for valid consideration, and the deed of conveyance was executed on 28th of November 2006, such a mortgage cannot be enforced by the respondent bank. This again is a factual question which can very well be agitated before the tribunal by resorting to an appellate remedy provided under the Act, as it has been held that the Sarfasi Act is a code by itself, and the writ code should refrain from refrain from interfering with the process, interfering with the measures initiated by the financing bank under the provisions of the Sarfasi Act. For the above reasons, the appeal fails and is dismissed. However, we make it clear that we have not gone into the merits of the contentions raised by the appellant, and it will be open to the appellant to canvass all points if an appeal is preferred before the tribunal under section 17 within bracket.
May I seek one illness, only the appellant time has been 45 days.
Since the appellant was full stop. After we have dictated the judgment, the learned advocate appearing for the writ petitioner submitted that in the event the appellant approaches the tribunal, the appeal should not be rejected on the ground of limitation. We find that the writ petition was filed on 16th May 2023, and the appeal and the same was dismissed on 18/4/2023, against which the present appeal has been filed, and the present appeal has been dismissed by this judgment and order. Therefore, the period from the date of filing the writ petition, namely 16/5, sorry, writ petition was filed
Annexure
12/3
12/5/2020. Next date nahi. Date nahi annexure.
Writ petition was filed in May 2019. Therefore, while computing the period of limitation, when an appeal is filed before the tribunal, the period from not May, sir, March. I said May. You make it March. March 2000. For period from 1/3/2019 till the receipt of this server copy of this order shall stand excluded.
But one clarification, a developer has not been mortgaged. Another purchaser has been
Might have,
might have. He said might have. Developer has not been mortgaged, my lord. Another purchaser, subsequent purchaser has mortgaged. That is the fact of the matter.
The fact remains there is a mortgage.
I'm grateful, Your Worship. 45 days.
Password, password.
Appellate side daily list, one password matter, serial number 10.
Yes.
10 minute I am for the appellate.
Yes.
But here is my affidavit of service, madam. Madam, tendering apology to file one copy of affidavit of service, madam.
Fourth respondent has been served.
Yes, madam. Only the state and the private respondent is there, madam. Only one number of private respondent, but presently he is in custody. In one POXO matter, madam, he is in custody. Madam, this writ petition, it was dismissed by the learned single judge, madam, on 9th of September 2022, and while dismissing, at the time of dismissing, my lord, the petitioner, he has been cost, my lord, awarded cost of rupees 5,100, my lord, and the cost should be paid to the police authority, my lord.
But
My lord, the fact of the writ petition is this, my lord, the petitioner, she is an octogenarian, not octogenarian, she is an ailing lady, my lord. She residing at that place, my lord. She is the owner, the landlady of that premises, my lord. The private respondent number 4, my lord. He was a tenant and in respect of one room of the said premises, my lord. There are so many other tenants also, my lord.
very good.
But this, after inducting him as a tenant, my lord, the appellant came to know that the tenant, he has some criminal records, my lord. And from that time, my lord, the petitioner repeatedly asked him to vacate the room and to leave stay some other accommodation. But he was not listening to that and he was not vacate the premises, my lord. In the meantime, this POXO case, he was arrested in this POXO case, and during this pendants and in his tenure of custody, my lord, his tenure to stay there as a tenant, it was also expired, my lord. And when he was arrested, the respondent number 4, the police authority took the key of that room only. The room is in dilapidated condition. And now the situation, one person, namely Karthik Shonkar, he introduced himself. He is also a criminal. Presently, he is on bail in some other matter, my lord. He introduced himself, one of the brothers of the private respondent. He is trying to use that room by occupying that room illegally.
And the police have handed over the key to that Karthik. No.
That I don't know whether police handed over the key to the Karthik,
But
or somehow he managed.
learned judge has dismissed it on the ground that you are trying to evict him by a writ petition.
But it is not so,
What
my
is
lord,
the
because-
prayer in the writ petition?
Yes, it is there in the petition. The difficulty is this, my lord, the letter, my lord. The letter I have.
For
annexed
render
the
all
writ petition.
police assistance for peaceful living. Is somebody causing threat to the life of the petitioner?
Yes, my lord. That person that is Karthik Shonkar, my lord. I mentioned his name in my representation, which I have annexed in the writ petition. That is at page 53 right now, my lord. Page 54 is the part where I mentioned his name. Second last paragraph. That we are under the impression that at the time of arrest of Kanchun Shonkar, the room it
Now,
is.
if there is a threat to life of the petitioner, probably the police can go into it. But how do they enter into a civil matter? And throw this person or this Karthik.
No, my
Shonkar.
lord. Presently, it is not possible to prefer any eviction suit against the private respondent because he is in custody, and petitioner do not know that how long he will be in custody. This is first thing, and second thing, my lord, his tenure, it was already expired. And he has some separate accommodation, as we came to know from the other sources, that in the same area he has already purchased a flat. That respondent number 4. he just left the premises, but only few staffs of him, my lord, he put there. And for that reason, I am unable to use that room, my lord. I am only asking the police authority that their presence, I can vacate the room, my lord, because it is in dilapidated condition. Otherwise, if the room will not be opened by the police authority, that Kartik Shonkar, each and every day will come to their premises and trying to encroach that room, my lord. And I have been also threatened or restrained by the other tenants of these 8 premises.
There is a suit pending.
No, suit is not pending. And that amount of cost, my lord.
Cost it can be deleted,
My
but
lord.
we are just thinking what relief can be granted in a writ petition. If we direct your a complaint to be taken on file, in the complaint you want the room to be unlocked, or probably inventory taken, then the articles to be kept in the custody of the police, and you have to be given vacant possession.
My prayer is very clear, my lord. I'm just asking the police to, in presence of the police will unlock the room, my lord, and whatever staffs that respondent number 4 has belonged to that room, my lord, just vacate keep those belongings of respondent number 4 and hand it over it.
But that in effect is a eviction degree. That is a problem. Only thing we can say is that a third person cannot enter. That much the police can ensure. To that extent, what is this? He is coming inside. Huh?
Yes.
Certainly, you have taken the keys and locked and tenant room occupied Kanchan Sarkar. But we have come to know brother of Kanchan Sarkar illegally using the room. He is not a party, but suppose he is not a tenant. But he is a trespasser. Yeah, to evict the 4th respondent, she can't do it to me. But if Kartik Sona is a trespasser, that too is not a party. You lodge a complaint if, according to you, this Kartik Sonkar is a trespasser. You lodge a complaint, we will direct him to consider your complaint.
Then, my lord, kindly keep this petition pending.
No. This
But
intra-court appeal.
very awkward situation is facing by the appellant, my lord.
This intra-court appeal by the writ petitioner is directed against order dated 9th November 2022 in WPA 8897 of 2022. In the said writ petition, the petitioner sought for a direction upon the respondent police to ensure that she peacefully resides in the premises owned by her, and there is also a certain relief sought for against the private respondent, who, according to the appellant, has illegally retained possession of one room in the said building. It is submitted that the the private respondent is involved in a criminal case, and at present he is in judicial custody. There is also a further allegation that a person claiming to be the brother of the 4th respondent, one Kartik Sonkar, Sonkar, is attempting to trespass into the said room, which one Kartik Sonkar has illegally using the room, and he is also involved in a criminal case. Further, the petitioners would state that the period of during which the private respondent was permitted to occupy the premises is already over, and the petitioner seeks for a direction upon the respondent police to unlock the premises, remove certain articles kept by the 4th respondent in the room, and hand over possession of the premises of the room to the writ petitioner. Such a relief cannot be granted, and rightly such relief was declined by the learned writ court, since it is purely of civil nature. However, if, according to the petitioner, Kartik Sonkar who's alleged to be the brother of the fourth respondent is a trespasser, it will be well open to the petitioner to lodge a complaint. Is a trespasser, it is well open to the writ petitioner to take appropriate steps in accordance with law before the appropriate authority. With this observation, the writ petition stands disposed of. However, considering the facts and circumstances of the case and the age of the writ petitioner, the cost imposed by the learned single bench in the impugned order is deleted. Next. 14.
I'm for the respondent license.
A copy has been served.
But I'm appearing for.
The issue involved, Lordship, is that the provision of 127 of the Electricity Act, which is an appeal after 126, done by the officer of the CSC, there is a scope of an appeal that has become a nugatory by way of the order passed by the Great Court in the High Court. Lordship may kindly see, the fact is that, in fact, the allegation is that in the month of October 2015, the CSC authority went to premises number 116 Mahatma Gandhi Road. Now, that Mahatma Gandhi Road, Lordship, is a very congested area in the central Calcutta under Jorasako police station. And the premises is 116, 116H by 1, 116H by 2, 116H by 3, 116H by 5. So it's absolutely congested locality. Now they found that there was an unauthorized abstraction of electricity supply for 116 Mahatma Gandhi Road. Lord, this premise is very important, Lordship. And they come to the conclusion or an opinion that electricity has been abstracted from 116 and be unauthorized used at 116H by 1. That is their case. And the appellants before your Lordship are the tenant in respect of 2 or 3 rooms on 116H by 1. This is their case. Now, Lordship may kindly come straight away to page 28.
Yes.
This is their order of provisional assessment. Now, the first line they start is, during my inspection of the aforesaid premises on 13 October 2015, I have come to the conclusion, Lordship, very important, that unauthorized use of electricity was indulged as under. Direct connection found from the service cutout of premises number 116 MG Road, Kolkata 70007, and the unauthorizedly abstracted supply was being used at premises number 116H by 1 MG Road, Kolkata 7. The beneficiary of the said unauthorized supply were found as above. My names are given in the top. Now, the basis of this inspection is on page 30.
Yes.
Now, this is the only document which they relied upon. Details of dehooking drive, area 116 Mahatma Gandhi Road. Road name Mahatma Gandhi Road, LP, dated such and such. Name of my appellants have been given there. Total estimated load such and such. Remarks, unauthorized direct connection from 160 MG Road. Now, 160 MG Road, whether the owner, whether the purchaser were responsible there, nobody has been touched. No finding here 116 MG Road. Straight away, just because I was the receipt of 116 H by 1, they put me that you are the person responsible, you are using the electricity, Lordship.
But there are several other tenants.
Yes, number one. Number two, they also relied upon few photographs.
Photographs will annex.
Oh, Danny.
Because all the annexes of the writ petition has not been annexed in the this.
No, I'm sorry if I missed that. I have got some photograph. I think.
All right, proceed. Please proceed.
Now, the photograph was respect of a wall of a building. Some white colored
wire were creeping on the wall.
Hmm.
That is the second foundation of their case.
Hmm.
First is 116 Lordship, nothing against 116. Second is that 116 H by 1, they are claiming that is the premises 116 H by 1, where there is a clipping of the wire, but they have not been able to establish whether that wall or the premises was at all 116 H by 1. Now what they do, they come with this provisional assessment, page 28. Thereafter, final order is passed. And now this I have showed you the inspection report also. It will not show or suffice that whether there was any other witnesses, there were other attempts were taken to find out or unearth who were the user of the unauthorized electricity. Nothing on page 30. No signature of mine. Nothing.
Yes.
Just a very arbitrary inspection report. And then page 31 is the final order of assessment which was challenged in an appeal. Now the appellate authority rejects their assessment.
Rejects the appeal.
Yes, appeal has been favored in my favor.
Okay.
Rejects their assessment and their findings. Is a finding of the CSC. That the order is on page 58. A detailed reasoning has been given there. This appeal was carried invoking the provision of 127 of the Electricity Act, Lordship. Now I will not waste the time of the Honorable Court. Page 60 is the observation of the appellate authority. These are the finding of the appellate authority, Lordship.
He says based on that whatever evidence, there is no scope to sustain the allegation of illegal abstraction.
No. It says that there may be an abstraction of unusual electricity, but the appellants are not responsible. Kindly see the final part. Order. Hence, I pass the following order. I, being the appellate authority under section 127 of the Electricity Act 2003, unable to say that the assessment made against the appellant is justified as indicated above, and accordingly the same is hereby quashed and set aside. However, the respondent CSC Limited is at liberty to take appropriate action against the appropriate person committing such unauthorized use of electricity after proper verification of the address, and thereby persons belongs to such premises if it is otherwise permissible under the law. So it is not a simpliciter case that no, there is no abstraction of unauthorized electricity. Appellate said there may be. You take action. But these appellants, from the finding from page 60 onwards, it has come to a definite conclusion that the appellants were not responsible. They are not the person. Now, this order has been challenged. Now, there was a criminal proceeding also against me. I'm not relying upon that much, because the charge sheet was written, resulted into an FRT saying that because of the want of evidence and because of this judgment, there is nothing against me. So I've been discharged from criminal case. But that is not the foundation or the basis of my case. Just because I've been discharged from or exonerated from a criminal case, I will take advantage of that, because both the proceedings are two different proceedings with two different consequences, Lordship. This is almost a civil liability, and that is a criminal consequence, Lordship. So I'm not relying upon much that. But my case is that the appellate authority, after considering the every aspect and giving a justified reason, it has been with a reason, has held that I am not the person responsible. Now the learned judge.
Now CSC challenged that order by...
Yes, in the High Court, 226.
Page 155, I think, the discussion starts.
Lordship. Page 1, I'm sorry, Lordship.
Para 19, 20 onwards.
20 onwards.
This is whether private respondent entitled to...
So paragraph 21, Lordship has discussed that because of the criminal case, it cannot be a ground for my exoneration, which I am also not harping upon. Paragraph 21, my Lord has held that just because
Supreme Court says it's independent proceeding.
Yes, I am not on that. I'm not on. 24 is relevant. Lordship has said that preponderance of probability. My Lord has held that. Here, the standard of proof is not just like a strict standard of proof in a criminal proceeding or some other proceeding. Here, my Lord says that just because the CSC failed, that there was a wire hanging on a wall, so it is enough and sufficient that they can proceed on that. Kindly see paragraph 24. onwards. Then paragraph 26. We tried to say that the wire which was found creeping on the wall is 116 h/5 because we are the local residents there. But that was not considered. Honorable High Court, the single judge says that these are the things, the CSC is consistent in their case that a pilferage took place. So there was a pilferage. And since they have found in the inspection report that you were the people responsible, but the inspection report does not say that way. Then paragraph 28 seizure list. 4 meters of PVC inside blank copper with hooking arrangement. From where, how am I responsible? Even the 116 h/1 is fully tenanted. Now, paragraph 32 should also like to show that Lordship, the learned single judge has relied. Another aspect of the matter cannot be overlooked. A liability assessment proceeding under section 126 of the 2003 Act is, after all, not a full-fledged civil suit or judicial proceeding. Even as per the language of the section, the inspection by the assessing officer has to be given primacy. Paragraph 32 of the judgment. Now, Lordship, I have shown you the inspection report on page 30. Yes, that has to be given primacy. But that inspection report does not suggest anything. One single page, the signature of the assessing officer is there, and they just mention my name, and they say from 116 there is an unauthorized abstraction, nothing more. So even if this thing is taken into consideration, primacy, then with all due respect and with deepest respect, Lordship, page 30, it's saying something else. With all my discrepancy, if these findings are taken into consideration, then 127 become nugatory. Then provision of appeal and the power and authority of the appellate authority goes away. Council के लिए मुश्किल से
Where is the appellate authority's order you just showed?
Lordship, page 60. 60 is the observation, which is important, Lordship. It start from 58, but these are the facts and submission. Then the appellate authority comes to page 60, Lordship. May I read it, Lordship?
No, we'll do.
Lordship. My lord, may kindly excuse me, that moreover, I am told, if your lordship has come to that line, only say, kindly see 135 1A.
আছে তো বই যশোরের বই আছে একটু আরো ভালো বই
কিনেছি, নতুন কিনেছি। এটা নিউ আছে, হ্যাঁ।
Yes, moreover, I am told that the appellants are still enjoying electricity from their respective
Yes,
meters.
kindly see 135 1A.
Yeah, this is a new book, is it?
It's a new print.
Amendment has happened?
No, no, sorry, lordship, but I want,
Oh, we have got this.
I wanted to assist the
New book. Thank you, thank you. At times it is required.
135 1A section.
Disconnect the supply.
Not disconnect. Hadn't been the case of unauthorized, my land should be instantly disconnected, which was not done.
Sir, two questions. One is, there is an observation of the learned judge or finding saying that preponderance of probabilities. Theft is a criminal offense. Theft is a criminal offense.
this is unauthorized use of electricity.
Because you see what is unauthorized use. 126, you please take 126. The explanation.
Yes, your lord.
Under 126, for the purpose of this section, clause B, unauthorized use of electricity means the usage of electricity by artificial means or by means not authorized by the concerned person or authority or licensee through a tampered meter or for the purpose other than usage authorized premises area for those stipulated was. It's a very widely. So it is in fact that it is an unauthorized use of electricity. This is also given rise to a criminal case.
But all unauthorized use of electricity are not criminal offense.
But in this case, a criminal offense has been registered. Forget about the finding, whether he has discharged, etc. But can you say that by preponderance, I will say that there is unauthorized abstraction of electrical energy? Because the allegation which is found in the provisional assessment order, the first notice of provisional.
Page 28, lordship.
38 at 39. 28, sorry.
28, 28.
Direct connection found from the service cutout of the premises number 116 and unauthorizedly abstracted supply was being used in 116 H1.
Lord, I never use the term pilferage or theft of electricity.
No, it is unauthorized abstraction.
Unauthorized.
Otherwise, we won't bring it in under 126.
No, my lord, I tell you, lordships, there is a, my lord, judgment of our High Court of the Division Bench that an unauthorized case of electricity is different from a pilferage case of electricity. My lord,
No, we will not go to that. It is a case of unauthorized
use of electricity.
electricity.
If it is an unauthorized use of electricity, my lord, the preponderance of probability theory applies.
But he has
In a nature, your lordships, it depends upon the case. By hooking from one premises where meter was there, supply is taken out to another premises.
That evidence is lacking.
No, that evidence we have seized the wire, we have produced it. Admittedly, that is not
in the
denied.
final assessment order, the reasons or observations are something more than in the provisional assessment. Provisional assessment says from 116, the connection has gone to 116 H5.
Exactly.
But if you see page 33, photographs.
I tell you, lordship, kindly, pardon me, 28 then. We have prepared a report of my inspection at site. Then photographs have been taken during such inspection, which are also enclosed. These have been considered at the time of final order. Photograph shows that this has gone from this to that.
Because in page 33 also he says photographs are taken by the photographer as instructed during the inspection. Photographs are indicating clearly the premises where the above persons are residing and were enjoying electricity by unauthorized direct connection. from the cutout of the adjacent premises 116.
Well, your losses kindly see section 126. This is the best judgment.
White colored wire is clearly visible creeping on the side wall of the premises H1, taking entry into room number, one room in the third floor.
Well, there are evidences. All the annexes are not here. The local evidences are also there. Being appearing for licensee, if this is a case of simplicity or meter tampered, that's the best evidence. But in case of hooking, I have to depend upon the circumstantial evidence, local inquiry, and that's why 126 demands the assessing officer must be present with the team. This is the assessing officer, and this is his best judgment. That's why I sought the judgment, but that judgment learned single judge has not accepted totally in the income tax matter. The best judgment of the officer, assessing officer.
Yes, best judgment assessment, the easiest definition is guesswork.
Guesswork, and your loss.
Mr. Rai knows. But guesswork cannot be a wild guess.
Exactly.
It can't be a wild guess.
That must be some material.
Yes.
That's where goes to that premises. He has never denied that he is a resident of that premises.
That is one question. The second question would be scope of interference under 226.
Exactly, your losses. If it is a perverse.
But it has the judge record.
Held that. If this is a non-consideration of the material evidence, kindly visualize. Can the appellate authority say disputed question of fact? That's the fact-finding authority. Page 61, your losses. Findings.
It is very difficult to ascertain as to whether the appellants at all committed such unauthorized use.
Is it he's giving benefit of doubt? And disputed questions of fact. He is the
where is that statement, local statement?
That's your loss. My learned friend has not annexed all that.
We have annexed there, but I have not received those copy.
That's the today, I have not all. This has been recorded over there. That they are the beneficiaries. Now I tell you losses, today.
That is not in the order passed by the letter single judge.
But one more thing I'm saying your losses today.
White color wire is clearly visible creeping on the side of the wall, taking entry into room third floor of the
Now one more thing. This is an application for stay. My learned friend asking for stay of the.
He's argued the appeal itself. So I was what more for stay?
That's your losses. Your losses. That's your losses.
Writ petition.
No, your losses.
All right, you file that document, we will consider. And discharge order you have enclosed? Criminal case, page number?
That's your losses more vital. Kind level.
Page 62.
Page
64.
64.
Which has been typed on page 65.
65.
Your losses type copy kindly. Page 65. May I just read out? That around before 13/10/2015, accused persons committed loss of electricity by hooking issues the PVC copper wire and thus illegally used the electricity which caused loss to electric company. In course of investigation, such examined of PO and made witnesses. In course of investigation, it was assistance from advocate. If the accused, namely Molloy, saw that the accused person attained before the electricity was seized or failed to produce any evidence against the accused person attained, I was allowed. I was a typographical mistake. In this respect, they also submitted a letter annexing with the order whether the pleased the CD necessary recommendation now was arrested electricity was illegally where none could be filed. In view of the above fact, in law concluded for FRT. What sort of FRT, my lord?
No, this is an order passed by.
No, this is the charge sheet copy which has been submitted.
Police filed an FRT.
Police said
that there is no evidence. Want of evidence, so.
But police sees the wire. Wire is lying with the police.
So that's
on the basis of advocate. Everything was filed.
Lordship, that's it. Ipso facto cannot be that it belongs to.
No, we will decide the legal issue. That is
the legal issue. Your lordship has to, my lord, where the theory of preponderance of probability, but why I'm saying your
Please
lordship,
file that local state.
your lordship,
Third judgment reserve.
and the other thing your lordships kindly consider, just now your lordships pointed out to my learned friend, the parallel proceedings. Parallel proceedings, continuance of the parallel proceedings, it says comes out from the service jurisprudence.
Correct.
But in very next matter, I will argue contrary to that. But your lordships, if the service jurisprudence principle applies, the theory of preponderance of probability in case of 226 assessment applies by nature of the proceedings. I can enlarge, my lord. If your lordships go, my first point, your lordships, to that, 126 assessment is really, unless it is a theft of electricity, if it is a simplicity or unauthorized, that's another issue. But it is coupled with the theft of electricity, 126 assessment is an temporary order. Because if there is a criminal case, your lordships, of the theft of electricity, and the person is discharged under section 154(5), that order of assessment goes. This is not the case here. The very next matter I will be arguing for the consumer. That's the theory of service jurisprudence applies, and therefore preponderance of probability will be.
Yes.
Good.
Next.
Serial number 15.
When you can file that, sir?
That's only one page. I will just give you lordships to do.
So may I have the copy of that also? I
Yes.
don't know.
Sir,
The copy আমাকে দিয়ে দেবে।
ব্রিফের মধ্যেই আছে, আমি তোমাকে পয়েন্ট আউট করে দেবো ওভার ফোন।
কাছে নেই।
আরে ওখানে দেখানো হয়েছে। টাইম নেবে। আমারটা কই?
On behalf of the respondent, Mr. Sumit Kumar Panja is appearing. He is my lord deal.
Well, my learned friend is quite competent, my lord. This sort of matter, my lord. My lord, because I tell you losses, my lord.
My lord, when it is my lord, company's matter, when senior was appointed, it is my lord, I shall be in some.
My lord, may I pray for this then? My lord, I'm without electricity. My lord, I'm hard pressed because I cannot marry my daughters also, because the last 10 years my business
When
is
is the
closed.
marriage fixed?
I beg your lordship.
When is the marriage fixed?
Marriage, my lord, I can't have the money even.
All right, where is the bride?
My lord, I tell you losses why.
You show the photograph
My
of the
lord, I
bridegroom.
can't do that. It's a hands and
Only you are searching.
hands and mouth. Hands and mouth. I tell you losses. This is a husking machine business. My lord, husking machine
I say
business.
husking.
My lord, claim was of the assessing authority 3 lakhs and odd. I have already paid, my lord, 50% of the amount. I have been discharged, acquitted from the criminal case. But my point goes, is the theft of electricity. If I am acquitted from the criminal case, then my lord, assessment order goes because 135(1)(a). That's my lord, there is no judgment as of. Your lordships have pointed out in the earlier matter that is a parallel proceedings. These parallel proceedings only, if I ask for restoration during the criminal pendency of criminal proceedings, I have to honor that assessment. But if I am ultimately acquitted on the same charge, then my lord, that assessment order cannot remain. That's the point, my lord, point to be considered. And I have paid 50%. I have acquitted. Let them restore my supply. Let me survive.
No, you file an interim application, we will consider.
This is the application, my lord. Application for appropriate order.
No, this is.
My lord, this is an application for appropriate order in connection with appeal. My lord, can 1.
Oh, can 1. Then let them get instruction on that.
That's
And what was the allegation?
Allegation was the theft of electricity by hooking. And they seized the meters, the materials, but they could not produce anything before the court, criminal court, no evidence, and then I was totally acquitted.
Pass an order restoring the supply.
Is 2006, my lord. That allegation of theft in 2006.
But this punishment of for all these years, now we are in 2023 without electricity.
My lord, under the provision of law, if in case of assessment, if he paid the amount, he paid 50% according to my management, then he will.
What is the total demand?
My lord, I just your losses. I give your losses. The total demand I find your losses 3 lakhs and odd. I paid 50%.
1,39,000.
I've paid 50%. But my lord, according to ultimately on appeal, I want refund of that money also.
That is correct.
That's your losses another aspect.
That is it.
But point of law, if your losses kind level look,
No, you pay another 25%.
And I am undone, my lord. I really am
Now,
undone.
what
My lord,
he-
I tell you, losses.
No. What was he doing from 2006 without electricity?
Nothing,
did-
I can't do it.
Another hook somewhere.
No, my lord, no, I can't run the business. I my lord, kindly do not go have that much of impression. This is not such a case. But this is a pro bono matter we are doing. Just because I'm fighting for this law for the last 5 years. Kindly come to a conclusion.
Therefore, it is a good case. We will entertain the appeal. Another 25%, another 25,000 you pay. We will direct them to restore electricity supply. Probably by September, we'll fix a date for the appeal.
25,000.
1,39,000 paid plus another 30,000 or 25,000. Round it off. Where is the demand notice? I mean,
Demand notice, I tell you, losses. That your losses will find at page 61. The total claim, my lord. There is another. No, I just tell you, losses. My lord, page 59.
59.
Lord, I believe, my lord, I have paid 50%. 278,369, 2,78,000 and odd.
you have paid 1,39,185. Another 30,000 rupees.
To that your losses. But subject to the appeal your losses,
Yes,
any
yes.
payment your losses, kindly, my lord.
Uh,
And one request to your losses. This point of law, your losses kindly fix up any day, my lord. This is a pure question of law.
First, you finish your panchayat matters, then you.
Oh, really, that's true, my lord. We are not
That is
getting
the-
hurt. Really,
That is the trump card we are going to play for all advocates who are appearing in that matter and.
no, I will restrain myself not appearing in those matters.
No, no,
Not
no.
today.
You have to assist the court. This intra-court appeal with writ petitioner is directed against the order dated so and so in WPA 23810 of 2006, by which the writ petition filed by the appellant challenging the assessment order passed consequent upon a charge of theft of electricity was dismissed. The learned advocate appearing for the appellant would submit that a question of law arises for consideration in this appeal. Namely, the effect of an order of acquittal in a criminal case registered on a charge of theft of electricity on a proceedings initiated under section 126.
Yes, my lord, discharge under section 135.
126 of the Act in the light of section 135 of the Electricity Act. Considering the fact that such a question has been raised and the learned single bench has ruled against the writ petitioner, we are of the view that the writ petition we are of the view that this intra-court appeal can be entertained. Accordingly, the appeal is admitted for hearing. The learned advocate appearing for the appellant would submit that though the appellant had paid 50% of the demand by remitting a sum of rupees 1,39,185, till date the appellant has not been till date the electricity connection to the appellant's premises has not been restored. Considering the fact that we have entertained the appeal and that the disconnection took place in the year 2006, we are of the view that the electricity connection can be restored in favor of the appellant subject to certain conditions. Accordingly, there will be a direction to the appellant to pay a further sum of rupees 30,000. And on receipt of the same, the respondent shall restore the electricity connection subject to payment of the other incidental costs such as reconnection charges, etc. Within a period of 10 days from the date of
Only one thing, my lord, line was disconnected in 2006.
Ah.
Therefore, my lord, other formalities regarding the testing of the line, it's required by
Within a period of 30 days from the date of
subject to compliance, other formalities.
the date on which the appellant remits the sum of rupees 30,000. If any other incidental charges are also are to be remitted, that shall also be remitted by the appellant. It is made clear that the amount which was paid by the appellant, the amount which is to be paid by the appellant shall be subject to the outcome of this appeal and abide by the orders to be passed in this appeal.
And one indulgence, my lord, that subject to compliance, other formalities in respect of that. No, line was disconnected in 2006.
Let's say two things, sir. Disconnection is different from dismantling.
Yes.
Suppose they disconnect and dismantle from the pole to the premises, you have to pay.
But they will draw the supply line.
No,
But
no.
that, my lord, I tell you losses. When I got the connection, I paid everything.
Now you lost the connection, you pay once more.
My lord, if I lost the, my lord, they have also, my lord, taken away my security deposit. There is a security deposit that's still in their hand.
That is why, that is why 2,79,000. That would have been adjusted against the demand.
My lord, they could have, but they cannot, my lord, because the assessment is pending.
You have said incidental.
My lord, incidental, my
And
lord, charge
other
cannot.
formalities, because, my lord, it requires electrical inspector's certificate regarding the
That I will give you loss. That I will
installation of the.
Except monetary charges, I will give everything.
If the appellant is required to furnish any certificates for the purpose of securing the reconnection of the electricity, the same should be complied with by the appellant, and time taken by the appellant for complying with such requirement shall be excluded while computing the 30-day time fixed by this court for restoring the electricity.
So for the, my lord, let them file an informal paper book so that your losses can take up the appeal. Because or your losses has to take up on the stay application itself.
If all the documents are here, then we can stay
Everything is there.
Then, since all the documents are annexed in the stay petition, the filing of informal paper book is dispensed with, and submissions will be heard on the documents available in the stay petition.
Or may I plead for one more indulgence? In the month of September, leave aside Panchayat matter for the month of August, my lord.
Oh, you are confident it will be over in August? Thank you very much.
In the
Thank
month
you.
of, because of the point involved, my lord. In the month of September, your losses.
September is full, October.
October takes us to the puja vacation. Your losses will also go to your losses.
No, that puja vacation starts only on
20th.
5th October.
Much.
List the appeal on 5th October.
Serial number 16.
Well, I am for the evidence.
Yes.
Appellant. This matter on behalf of the additional solicitor general, let this matter be taken up.
What is freedom fighter?
Yes. Well, this is the freedom fighter's pension.
That is what we are
Not
asking.
pension. The area of lifetime area of freedom fighter pension. Well, fighting, freedom fighter died. Then wife came. Wife died during pendency of the contempt application. Then in contempt, liberty was given to the appellant hearing to challenge the application. We applied, we challenged that in a read application, paying for the lifetime area of freedom fighters pension of my father and the mother till the death of my mother.
Did the son take care of the mother?
No, as far the freedom, father did not get. Father was
during the lifetime of the mother. Did this Mr. Chakraborty take care of his mother?
Yes.
What is he doing? He is working somewhere?
No, he is cultivator. Well, he is a cultivator of the district of Midnapur who took part in the freedom movement.
Son.
Son is the Muktipada, is a priest of the local area. Some does the puja and such and such.
They are in big demand.
Only the livelihood that.
They are in very big demand.
Well, only that profession of puja and something like. What is the point involving this matter?
No urgency.
No urgency is that.
No.
The point involved.
Freedom
it has
fighter
been
dead and
decided
gone,
by
wife dead and gone, son is a Purohit, he is earning well, ESG is not there. So
But
let it,
as my learned friend is granted, I cannot stand on the.
yes.
No, I never stand. But can I pray only on the adjourn for a little date and let it be happen at an earliest possible date so that your lordship can decide it.
Difficult, sir.
Well, I can pray that, but you'll consider
All
that.
right.
Since
The respondent so-and-so has accepted notice for the respondent. It is submitted that the learned additional solicitor general is appearing for the respondents and adjournment is sought for. Considering the facts of the case, we find that there is no urgency and the appeal itself can be taken up at this stage. As all necessary papers have been annexed in the stay application. Let the appeal be listed for hearing on 28 September.
In that event, your lordship dispensing with the preparation of paper book, kindly have that order.
All right.
Otherwise,
All right. The paper book dispense. Next.
Preparation of paper book is wait.
Serial number 17.
Claim for that.
Hon'ble.
Claim for the appellant and writ petition. Challenge the order of 2nd of May 2023. Possible under single judge, my lord. But first I tell the fact, my lord. On 31st of January, my lord, this petitioner, the wife got a phone call that his husband has been made an accident in the road. Well, let's see, rush to the spot and find that, my lord, he's not an accident, he has been murdered. On the next day, my lord, complaint has been lodged against unknown person, and its complaint started under section 302, 201, 34 of the Indian Penal Code. My lord, investigation has been started. My lord, 2 persons has been arrested. My lord, kindly consider page 48 first of the stay application, my lord. Written copy, my lord. Lords has got it, my lord.
What is the prayer you have sought
prayer,
for?
my lord.
No.
My lord,
Commanding the respondent to show cause why respondent 5 not arrested till date.
Kindly see page 40.
This sort of writ petition is not maintainable.
Kindly see
This sort of writ petition is not maintainable.
It's a wrong order. Kindly why I saying, my lord, that. My lord,
Prayer in the writ petition is not maintainable.
my lord, case 69, my lord, trial court, my lord, is observed that, my lord, already, my lord, charge sheet has been submitted and trial has been commenced. My lord, from the record, my lord, is still not arrested and ministry is still open. Well, on the open platform, that person, my lord,
spoke the other remedies available under CRPC.
My lord, he has been threatened in the local platform in the YouTube, social. He admit that I commit the murder. Is it in the record, in the police record?
And why the police are shielding him?
I don't know. He filing the petition here, but before this honorable court, police could not find him. My lord, page 48.
No, the court has recorded that the Superintendent of Police Howrah Rural is supervising the matter.
My lord.
Charge sheet has been filed, trial commenced. Accused has been declared as a proclaimed offender. And therefore, where is the police inaction?
Kindly see page 49. Charge sheet is not submitted against this person. Investigation is still opening against this person.
What is your
page
report,
49? My lord, is written there, my lord.
No, he is. What is the name of the accused?
His name is accused Manik alias Srikant alias Muni Sarkar.
So he has been declared as a proclaimed offender. Therefore, the trial.
Thereafter, then police did nothing. I am the victim. I am the worst sufferer. The duty of the state to produce the accused person. Kindly see page 45. Observation of the. He filed a revision application for quash the proclamation
and
order.
What have you done, sir? He is a proclaimed offender. You will file a supplementary charge sheet. But should you not investigate at least where this fellow's whereabouts?
If you
from 2021
report, well, entirety from time to time we have placed all the records proceedings before the trial court. Well, there it has been declared as a proclaimed offender in our at our instance. Well, we are trying. We have gone there. It is closed. So far as the allegation of threats are concerned, he is nowhere in the local. Every day there is a visit. It is still under progress. We are saying already enforcement branches also trying. It has been handed over to us.
He's
We
a
are in the
passport
local
holder.
jurisdiction,
His
my lord.
passport ever been seized? Never.
My lord, we have to get that particular person, my lord.
My lord, it's a duty of the
This is
state.
a lock and key, my lord. We have categorically stated what steps we have
But
taken.
it's a lock and key, and in filing the petition before this honorable court.
Yes, that has been already dealt with, my lord. If your
Page
lordship-
55, can you see the observation on a single judge?
We have issued warrant, we are trying, my lord.
Now, what is the direction given by the trial court to the police?
My lord, he is the absconder, my lord. Thereafter, it has been taken for this attachment already. We are saying that if your lordship kindly takes up the page 2, my lord, paragraph 4. This refers to my lord, fifth line, this refer to Bagnan PS case such and such.
By going repeatedly to the locked premises where you will find, you have to form a special team and try to find out.
There, we are already still on, my lord, but whatever directions has been given by the learned court below, my lord, we are
Still on from May 2021. Like, can I see page 55? This honorable court, he come before this honorable for quashing of the proclaimed offender.
It is not.
The honorable court observed that I am not inclined to permit the petitioner to play with the process of the court on the ground that alleged defect in the order of the learned additional session judge first court. Please categorically observed by the under single judge in the criminal proceeding. Like that accused person came before this honorable court, police cannot find him. Well, he came here to affirm this affidavit, filing this petition. Everything is there.
Where you are
Like page 55, please. Like page, this order start from page 53. What is the CRR proceeding?
This is filed by the proclaimed offender.
Yes, in 2022. And this of proclamation order has been issued in 2021 in the May.
And thereafter, my lord, the entire house.
Only for table work and nothing.
Particularly keeping watch and vigilant over there, the entire house is also under lock and key, entire house. Nothing is there.
Only one
They are neither
paperwork.
using it, neither coming for a. My lord, there has also been an observation, my lord, at page 56.
Yes, it dismissed the petition.
We are also ready to produce the further reports also. That is not.
Well, only
because we are
table
also-
work. They only produce only report and report.
See,
And my lord,
this is a very serious matter. He has appeared before the court, or rather he has come to
My
the
lord,
court
yes, yes.
and he has affirmed an affidavit or something, and the matter was heard, court has dismissed it. In spite of that, if you are not able to, then obviously police is
My
shielding.
lord, may I humbly submit, my lord.
Police
My lord,
is shielding.
he is not before us, my lord, at least before the court.
No,
He
no,
affirmed.
you had notice, sir. Sir, this is
State
an
already
application
appeared.
under 397 401. Read with 482.
Yes.
Notice was issued to the respondent police.
and my lord, state appeared
that
on that
has
matter.
So therefore, when this fellow was there in court, should he not have asked the court to say, ask him to
was-
surrender?
My lord, may I take it? He was there in court. What is it?
State is represented.
State is represented. Mr. Sopan Banerjee and Sumonde.
My lord, they are, my lord, but what?
Sir, as a prosecutor, what will you say? If he files an application for anticipatory pay, if it doesn't require an affidavit, if it does require an affidavit, as per our rule, he has to come here. During COVID, notary public. So at least that fellow had to go to a notary public. Here, according to him, he has come here and affirmed this affidavit. And the first reaction should be, please tell the court, ask the accused to surrender. Then we will make your submissions. The court records, he has neither moved an application for anticipatory bail nor surrendered before the court. Therefore, it's a clear case that the police is shielding him. It's a case of 302.
My lord,
Initially is put
we'll
it's
come with a
like a
specific report,
accident.
my lord, let 1 week be given, but so far
Only
my
report, my lord,
instructions
is
are, my lord.
doing only report to
The
report, my
superintendent
lord.
of police is also viewing the matter through binoculars and
Not that, because he's not a very that important person that we have
Yes,
to.
yes, in open
After
platform, he's saying I'm did the
And
matter.
every time we have to.
don't
My
do
lord,
this.
my lord,
Running
my lord,
commentary will not help.
apology, my lord, my lord.
Well, we have already, we are not sitting tight. We have tried our level best, my lord. And every time we are reporting to the
The intra-court
court
appeal
below, my lord.
is directed against an order by which the writ petition was dismissed. Writ petition filed by the appellant was dismissed on the ground that there is no police in action. The appellant's grievance is against one Manik, M-A-N-I-K, alias Mani, alias Srikanta Sarkar, who is a proclaimed offender in Sessions case number, in GR case number 224 of 2018, correct?
Yes. Yes.
Under section 302/201 IPC, which was pending on the file of pending at the relevant time on the file of the additional chief judicial magistrate Ulubiria. Before this court, the inspector in charge, Bagnan Police Station, Howrah Rural, has filed a report dated 21/6/2023. The report is verbose and not specific, probably with a view to give an impression that the police are taking effective steps to trace the said accused who has been declared as a proclaimed offender / absconding accused. And interestingly, the said accused had filed a revision case before this court, an application before this court under section 397/401, read with section 482 CRPC in CRR number 2219 of 2021. The said criminal revision along with the applications were dismissed by order dated 18/8/2022. It is a submission of the learned counsel for the appellant that when the accused had approached this court and affirmed to an affidavit and filed the case, it is unbelievable that the respondent police are unable to apprehend the absconding accused. The submission made by the learned counsel for the appellant appeals to this court, since it is totally unbelievable as to why the respondent police were unable to apprehend the accused, though they had full knowledge that he had appeared before this court in CRR 2219 of 2021. It is also not clear as to why the police did not seek for a direction from the said court to direct the absconding accused to surrender before the concerned court. Thus, it prima facie appears that there is police inaction. Therefore, the case, which is now being investigated by the inspector in charge, Bangnar Police Station, Howrah Rural District, be transferred from his file to some other efficient police officer, and an order to the said effect shall be passed by the Superintendent of Police, Howrah Rural District. The absconding accused should be apprehended and apprehended not later than 15 days from the date of receipt of the server copy of this order, and a compliance report should be filed before this court. The Superintendent of Police, Howrah Rural, shall exercise, select an efficient and energetic officer to complete this exercise, who shall file the report on the next hearing date. List the matter on so and so date.
Get.
Okay.
Serial number 18.
Madam, for the petition. Appellant. This is the affidavit of service. The grievance of appellant before your lordship is that he was holding passport from the year 1994. Till 2013, he was having passport.
In 2020, that is he did not renew. In 2020, he failed to go Hajj. So he again applied. This time, an objection came from the concerned authority.
Which authority?
The passport authority.
Regional passport.
My lord. My lord, may kindly come to page number 34. If your lordship permit me, then I will read the objection. Lordship, we're getting page 34. Now, this is in reference to receipt of an adverse police verification report corresponding to your application for passport issue with file number such and such. Subject involved in criminal case wide Hastings PS case number 63. Date is important. 4/3/1995. I was holding passport from 94 to 2013. In the meantime, it was time to time renewed. Phrase booklets were also issued. Now, my lord, this was the reason my passport was not issued. Now, my lord, I wrote letter to concerned authorities on 10/3/2023, that is page 39. And also to the concerned Hastings police station at page 35. I asked them specifically what are the case pending against me, and so whether it is pending in nature or not. No matter what, then I filed a writ application since they didn't comply.
No. In the writ application, it is you said that you have been discharged of the.
Yes.
Where is the order of discharge?
Well, that order we didn't process because it is long back 35 years. So we applied for the concerned police station since you are the authority concerned who has posted the particular website with the word pending. So kindly, I asked them to provide the details. Now they didn't provide. So I filed a writ application before the concerned Hon'ble court. Now, my lord, kindly just come to page number 80. This is very relevant.
80.
80, the last one. The authority replied, well, this is important. I'm reading the entire. Kindly refer to your letter dated 10/3/2023 pertaining to the above subject matter. It is informed that undersigned received your letter 21/3/2023. As per instruction of DCSCO, I am here to answer the queries made by you. It is hereby mentioned that whenever an applicant applies for a passport, that is phrase renewal etc., the passport authority forward the said application for police verification. The major point of the police verification is based on 2 points. First, whether the applicant is citizen of India or not. Second, whether any criminal case is pending against the applicant or not. In case of former, the concerned verifying officer verifies the document, which is voter ID card, birth certificate. It is to come to the conclusion that the applicant is an Indian citizen. In regards later, the verifying officer consults the database of crime record. If any case is pending against the applicant, the passport office is informed accordingly. In Kolkata, verification is done through online system. And if any of the above 2 points are not positive, the police verification report PVR automatically becomes adverse. It is further mentioned that onus lies on the applicant to prove the present status of the case. Due to heavy workload and paucity of time, it is not feasible to check detail of every case of PS level. The verifying officer has to solely depend on crime record. In respect of your client such and such, a wide cases is shown pending against him. So the authority who has posted the data on the online is the concerned police station. Now they have posted it as pending. So
they don't have records.
They don't have records. Now I am waiting for my passport. Everything is clear from 94 to.
Have you applied before the concerned court?
No, courts are changed. There was authority who was holding the court in the Bangsal area, and subsequently division of police stations were there. Now records are not being found. And they are saying that I have to give the GR case number to apply the.
So passport was issued in the year 1994. 94. Then when was the first renewal?
My lord, my lord, may kindly come to the list of dates I have filed.
Where is it?
The first list of in front, my lord.
In the memorandum, is it?
My lord, the MAT memorandum of the fewer pages combination.
Yes.
Yes. Lordship, 5/1/1994, the passport of the petitioner was issued. On 15/4/1999, the extended by the issue of phrase booklet, since it was over. Second, 2012/21, the passport of the petitioner was again extended by the issue of phrase booklet. On 1/1/2004, the passport of the petitioner was further extended by the issue of phrase booklet, which was extended till 31st December 2023. And thereafter, my lord, I again applied a gap.
And according to them, case registered in the year
1995. So 94 to 2013, my lord, I was holding passport.
But you are asking him to prove something which is virtually impossible.
35 years.
We are not able to trace our case file, 10-year-old appeal. Supreme Court says finish off 20-year-old cases. We have asked for a list. Department is still searching. Here and there files are there.
And Landlord says a discharge. What is the proof that he is a discharge from the place?
He says that it is
So
discharged.
where is proof?
But
Show me the papers. This is the discharge. There is no
we will
record for
issue
the
direction to you. We will issue.
papers of the discharge.
This intra-court appeal by the writ petitioner is directed against the order dated so-and-so in WP number so-and-so. By the said writ petition, the petitioner challenged the proceedings issued by the Regional Passport Officer, Kolkata, dated 2nd March 2020. This relates to certain clarification required from the appellant with regard to issuance of, with regard to renewal of his passport.
No, phrase I have applied since there was
For
gap of
issuance
7
of a fresh passport. In the said communication of the Regional Passport Officer dated 2nd March 2020, it is alleged that an adverse entry has been made in the police verification report, stating that the appellant is involved in a criminal case, Wide Hastings, PS case number 63, dated 4/3/1995, under section 399, 402 IPC, and the matter is sub judice before the learned court. According to the petitioner, he has absolutely no knowledge of any such criminal proceedings initiated against him. When this was communicated to the
my submission is that I have been discharged.
Where is the copy?
Wait,
Show me
wait.
the copy.
Please strike out.
Discharge.
according
What
to the
submission
petitioner,
before the court? Show me the
that
papers.
he had been
No
discharged
discharge.
from the criminal case. However, the appellant does not have any record to substantiate his statement. Therefore, to that extent, the regional passport officer is justified in placing the onus on the appellant to establish that he was discharged from the criminal case. However, one other very important fact which has to be taken note of is that passport was issued to the appellant on 5/1/1994. It was further renewed and a fresh booklet was issued on 15/4/1999. Thereafter, the passport was further renewed on 12/2/2001.
Yes.
And lastly renewed on 1/4/2004 till 31/12/2013. Thus, from 1994 till 31/12/2013, the appellant was holding a valid passport. According to the police, if a case had been registered in the year 1995, nothing prevented them from addressing the regional passport officer to withhold the appellant's passport or to refuse renewal. When an application had been made. According to the appellant, the records are not available in the concerned court on account of bifurcation of jurisdiction. When the appellant had represented to the police authorities, they sent a reply on 24/3/2023, from which it is seen that the police authorities have virtually stated that they have no records on their
report
file.
is there, Lordship. There is, he filed the report, that is, no records is there. I have submitted the report, Lordship. My Lord,
No records are not available.
yes.
And they have been directed to approach the OC Hastings. Thus, considering the facts and peculiar facts and circumstances of this case, we are of the view that denial of issue, refusal to issue passport to the appellant is not sustainable. However, such issuance of passport should be subject to the outcome of the criminal case if it is still pending. In the meantime, if the appellant is able to secure the copy of the order of discharge, it will be well open to the appellant to produce the same before the regional passport officer. However, for such reason, a person who had been holding a valid passport from 1994 should not be denied issuance of passport after its expiry in the year 2030. For the above reasons, the appeal is allowed, order passed and the writ petition is set aside, and the respondents are directed, respondent regional passport officer is directed to issue fresh passport to the appellant, subject to compliance of the relevant conditions, and such issuance of fresh passport shall be subject to the outcome of the criminal case alleged to be pending, if it is still pending on the file of the concerned court, which is not to the knowledge of the respondent, to the not to the knowledge of the police who registered the case against the appellant. Accordingly,
My lord, one thing, until and unless it is the certificate that is pending or not, how the passport officer to issue the fresh passport, lordship?
the above direction,
Kindly noted, lordship.
Claim of pendency has been made by them.
Because that is discharge is not certificate.
sir, you don't have any independent material. Your submission is based upon whatever the police has said. Police reply is neither here nor
That is no report.
the above direction be complied with within a period of 15 days from the date of.
That's the one line, lordship. If he is not to produce the discharge, that passport is not available. Because the problem is their lordship.
He is not a proclaimed offender, sir.
No, not a passport, but the main thing is the criminal case pending. If he is not discharged, then how the passport?
Next, please. Yes, sir. Thank you.
Serial number 19.
My lord, in item number 20, Mr. Pradeep Torpkar appearing on behalf of
19. আমাদের LBC, but it is item number 19.
my lord, 19, my lord, Mr. Pradeep Torpkar appearing on behalf of the petitioner. Now he is out of India, my lord. Kindly take it back, my lord, 19.
If they want some interim order, what to do?
Your Lordship, there is no scope for passing an interim order because my lord,
Lord,
it is essentially an order challenging refusal to grant an order of injunction on invocation of the bank guarantees. My lord, I have taken
And
instruction.
what happened to the main matter? Writ
My
petition?
lord, the main matter, there is a direction for filing of affidavits and they have come up in appeal challenging the refusal to grant injunction on the invocation. My lord,
kindly take it over, my lord.
When he is coming back from?
My lord, 5th, he is coming back. 9th, my lord, kindly take it.
my lord, I have also taken instructions that the amount under the bank guarantees have also been paid by DVC. And the bank guarantees, one of them are already released and the one is about to be released, my lord. So there is no threat of any
It is
invocation.
submitted that the learned advocate who has to appear in the matter is not in the country and adjournment is sought for. This is the matter on 17th August. Next.
Serial number 20. I'm appearing for the appellant writ petitioner, my lord. This appeal is filed challenging the order dated 12th June 2023. The writ petition filed challenging the particular notification, my lord, that is in the with my stay petition, my lord, being Can 1. I have challenged the notification dated 16th June 2010, issued by the OSD ex officio deputy secretary. This is.
Yes.
Your
You
Lordship.
challenge the terms and conditions of tender.
No, there is a classification made in the particular.
It was a policy of 2010.
Yes, it is a policy of 2010.
Now restricting the duties of the diet supply in hospitals in rural sector, having up to 50 beds to federations or clusters.
Yes, my lord,
or
kindly
self-
come to the notification first. Notification is at page 107 of my stay petition, being Can 1. This is, my lord, got it? 107. In compliance with the observation of the Honorable High Court as recorded in the order dated 20.
And this was issued in 2010.
Yes, still it is applying. And
All right, you are challenging it in 2023.
yes, still it is applying.
Sir, he is the inviting authority. He knows from which target group you have to get. You are a cooperative society. You are a larger organization. Self-help group is a smaller organization.
I say this classification is.
Nothing doing.
this classification.
We have heard.
My lord,
learned-
kindly have a look to this judgment, my lord.
No judgment is required. Heard.
My
learned.
my lord, there is a specific classification, my lord, and this classification restricting the others.
Classification has continued from 2010. When was your society formed?
That is one of the point of rejection of the appeal.
When was your
Apart
society
from
formed?
others.
Please answer the question. When was your society formed? Please show the registration certificate. Please show it.
My lord, I shall tender this on the
No,
next
no.
Wednesday, my lord.
No.
It was registered after 2010, my lord.
The petitioner.
And my lord,
Appellant is the writ petitioner and challenge the order dated 12/6/2023 in WPA 1641 of 2023. The prayer in the writ petition was to set aside a notification issued by the government of West Bengal as early as 16/6/2010. There full stop. The writ petition was filed in the year 2023, and it is an admitted fact that the appellant society was registered much after the.
It is a continuing cause of action, my lord.
Yes. Registered much after the notification was issued by the government of West Bengal, dated 16/6/2010. Therefore, the learned single bench was fully justified in dismissing the writ petition. The contention of the learned advocate for the appellant is that the dietary supply for the hospitals based on such notification has been restricted to one set of organizations, named
That is self-help group.
and self-help group. Self-help. And this, according to the appellant, is unreasonable. Admittedly,
Lord, my contention is that this notification is violating the Article 13 and Article 14, my lord. And this classification is unreasonable.
Illegal and
My lord,
discriminatory.
I am relying on the
Article 14 of the Constitution of India. Admittedly, it is a policy decision taken by the government, probably with a view to uplift the self-help groups.
My lord, kindly have a look to the clause 7, my lord. This is not only the rural hospital, my lord. It's also
We
block
find
hospital.
no error in the approach of the learned single bench while declining to grant the relief sought for. For the above reasons, no grounds have been made out by the appellant to interfere with the order passed in the writ petition. Accordingly, appeal fails, dismissed. Sorry, sir. Next.
Get serial number 21.
My lord, in item number 21, my lord, I am appealing for the petitioner, my lord. My lord, the appeal has become infructuous. My client has told me
The
to
learned advocate
withdraw
for
the
the
appeal.
appellant submitted that the appeal has become infructuous. Recording the said submission, appeal dismissed as infructuous. Thank you. Next.
Grateful, my lord.
Serial number 22.
In this matter, my lord, I am led by Mr. Parthasarthi Bhattacharya. Yesterday night, he has become sick, my lord. He has
But
not
I am
come
appealing
to
for the
court.
state, my lord.
Well, if your lordship can accommodate me for the day.
My lord, if I may
But
file
there
my
are
report, my
several
lord.
facets of this case, my lord.
My lord, the
So it
order
cannot
passed by the
just be
honorable
the
single judge,
judge,
my lord, has already been complied with, my lord. My lord, my learned friend is basically in this writ appeal, my lord, has been seeking a modification of the order passed by the honorable single judge, my lord.
My lord.
My lord, may kindly see the prayers of the writ appeal, my lord, the appeal which they have preferred, my lord.
My lord,
My lord, the honorable single judge has been pleased to direct me to file the final report within a month from the date of passing of the order. That order was passed on 19th of June, my lord. On 1st of July, my lord, I have already complied with the order, my lord. The report, my lord, I have annexed a copy
Now,
of the.
what is the relief you want?
Well, before I start, my lord, kindly seize, my lord, section 8 of the Foreigners Act, my lord. Before I start, my lord. Section 8, my lord. The determination of nationality. Section 8.
Yes.
When a foreigner is recognized as a national by the law or more than one foreign country, or where for any reason it is uncertain what nationality, if anyone, is to be ascribed to a foreigner, that foreigner may be treated as the national of the country with which he appears to be the prescribed authority to be most closely connected for the time being in interest or sympathy, or he is of uncertain nationality of the country with which he was last so connected, provided that
where a foreigner acquired a nationality by birth, he shall accept where the central government so directs, either generally or in a particular case, be deemed to retain that nationality unless he proves to the satisfaction of the said authority that he has subsequently acquired by naturalization or otherwise some other nationality and still recognized as entitled to protection by the government of the country whose nationality he has so acquired. A decision as to nationality given under subsection 1 shall be final and shall not be called in question in any court, provided that the central government either of its own motion or on an application by the foreigner concerned may revise any such decision. My lord,
No.
appellant has an unfortunate state.
In your memorandum, you say that the order requires to be order of the trial court, single bench, has to be modified to the extent to furnish the final report by respondent number 6 before the ACGM Alipur, considering the testimony. If you want a modification, you have to go before the single bench.
My lord, may I please, my lord, one second, my lord, this relates to a unfortunate state of affairs of 2 years, baby, my lord, who is a USA citizen. My lord, kindly cease, kindly please, my lord.
No,
my question is portfolio. The central government is the sole authority, my lord. All limbs of argument.
We are going by your memorandum.
Yes.
You want a modification of the order of the single bench. The prosecutor says that order and direction has been complied with.
The charge sheet
Charge sheet has been filed, my lord.
So you seek, if you want modification, you have to go review, you can go. How you
how foreigner act can apply, my lord, already, my lord. My lord, kindly fix it, my lord, next state, my lord.
No. You are
Then, my lord, kindly, record my submission, my lord.
My lord,
My central government,
my lord, they have preferred. This is the 4th appeal. In each and every case, the honorable single bench directed them to present before the regional passport authority. They have never appeared.
No, my lord, expiry order has been passed. My lord, they are completely misleading. My lord, kindly.
They are
my lord, let me open my case, my lord.
My lord, they are
already open.
My lord.
You see page number.
Let my nationality be determined, my lord. Let my nationality, my appellant, be determined.
We are not on that. We are not here to rule on your nationality. You are on appeal against an order passed by the single bench. What is the prayer sought for in this appeal?
My lord,
to modify the order. We are not here to modify the single bench order. And the prosecutor says the order has been complied with. You advise your client properly, sir.
My lord.
Don't raise your voice here.
My lord.
We can also raise our voice.
My lord. Excuse me, my lord.
No, we give you liberty. Whatever you want, you do.
My lord, twofold prayer was there. Number one, my lord, to consider my lord, police was so much harassed me, my lord. My lord, for this reason I came before the court, my lord, before the trial court. My lord, court below. My lord, there are twofold prayers. My lord, first prayer is, my lord, to file the charge sheet, my lord, within a time frame. Second prayer was to consider my documents. My lord, police has not considered my documents. My lord, already by ex parte order, my lord, my passport has been impounded. My lord, double jeopardy, my lord, out of same cause of action.
Impounding has to be challenged separately. Impounding cannot be challenged.
That has been challenged, my lord.
In this appeal, you essentially seek for modification of the single bench order. That cannot be done in a division bench. If at all you want, you withdraw this appeal and you file a review or modification before the single bench. Or we will dispose it off with that observation. That's all. This intra-court appeal is directed against order.
Then, my lord, liberty be given to file modification.
The prayer sought for in the writ petition in this appeal was to seek for modification of the order passed by the learned single bench. When we express that such a prayer cannot be considered in this appeal, the learned advocate appearing for the appellants sought permission to withdraw this appeal and proceed in the manner known to law. The learned advocate for the state submitted that the order and direction issued by the learned single bench has been complied with in its entirety, and a report to the said effect has been filed by the officer in charge, investigation cell, security control organization. The said report is placed on record. With the above observation, appeal stands dismissed as withdrawn.
Without considering my representation, kindly record it, my lord.
It is
charge sheet
made-
has been filed without considering my.
No. It is made clear that we have not gone into the merits of the matter in the light of the submissions made by the learned advocate for the appellant. Next.
I'm deeply obliged.
Next.
Serial number 23.
430.
My lord, I have for this respondent in this matter.
Ah.
Just one submission, my lord, before my lord, senior friend begins. The
Yeah,
copy
yeah,
of the copy of the petition served on us, my lord, is unpaginated, my lord. So it'll be difficult for us to assist your lordship. It's an appeal from an interim order passed in writ petition. Writ petition is also not, my lord, disclosed for your lordships.
50% they have directed to pay.
They have been directed to pay. They are not entitled to one single farthing, my lord.
It's an
And
admission,
interim
my
order has been passed. My lord, this is a contractual dispute. We should have been directed to file affidavit in this matter. And my lord, they had supplied fish feed to us, which was not according to the tender specification. Unfortunately,
And what happened? The fish all died.
Most of the fish feed was not according. My lord,
There is an admission, my lord, that there
is no admission.
Sanctioned payment to be made to me, and on that basis, the order is passed.
A reply to
When the writ petition,
Lordship.
court was satisfied that affidavit has to be called for. Then that itself means there is an arguable case. On
Lordship, the difficulty, my lord, on
But
three occasions notice served, they did not appear. My lord, the court went on
By
the basis of the
default.
admission.
Notice service to hai nahi hamare.
But in the meantime, what we can request is ask them to file the affidavit in opposition within a week.
Within a week,
and request the court to take it up within 2 weeks.
Please, my lord.
My lord.
In the
Meantime, 50%.
My lord, your lordship.
if your lordship will consider, my lord, directing this amount instead of being paid to me to be furnished, my lord, to the registrar of the court.
Not required. Government, we can always get it from.
Always.
This intra-court appeal by the
My lord, the
Directorate of Fisheries is against the interim order dated 15/5/2023 passed by the learned single bench, by which the appellant was directed to make 50% payment of the petitioners, of the writ petitioner's claim. From the impugned order, we find that the court was satisfied that there is an arguable case, and precisely for such reason, the appellant department was directed to file their affidavit in opposition. If that be so, we are of the view an interim direction to pay 50% would virtually amount to granting partial relief in the main writ petition itself, which will not augur well, which will not be appropriate, not augur, appropriate. Therefore, we allow this appeal and set aside that portion of the order, and with a direction to the appellant to file their affidavit in opposition, not later than, today is 27, not later than 10th of August 2023. If the appellant fails to file the affidavit in opposition within the said date, the right of the appellant to file their affidavit in opposition shall stand foreclosed, and the writ petition will be decided based on the available documents after hearing the submissions on either side. In the event an affidavit in opposition has been filed within the said date, the respondent writ petition is granted liberty to file their reply, if any, not later than 18/8/2023. The registry is directed to list the writ petition before the appropriate court in the week commencing 21/8/2023.
Extremely grateful.
My lord, I should also point out there was an 6 days delay in preferring the appeal. A condonation application has also been made. I'm not making an issue of it.
50,000 cost payable to the writ petitioner.
Well, we have taken out a section 5 application. We have taken out.
Control. Now, we'll stop with this.
But only before your lordship raises only one request with regard to that item number 2, beating of drums.
Beating of drums.
That order will be uploaded in the server today.
Order ready, beating of drums. It's gone to Lordship chamber.
Because it has to be sent to the concerned authorities.
No. Now Lordship will sign it and we'll see it and we'll sign
I'm extremely
it.
grateful.
And half an hour probably it will be uploaded.
Extremely.